Hey everyone, a very good evening to all of you. Welcome to the Officers Adda 24/7, the special YouTube series of your LRB subject, in which today we are doing the marathon of your LRB subject in the English medium. First of all, a very good evening to all of you. Hina ma'am, Ranjita ma'am, Mudu ma'am, Babita ma'am, a very good evening to all of you. So class, today is the 17th June, but still we are doing the marathon because today, especially for the English medium candidate, we are doing the marathon in which we will cover each and important topic of your LRB. As you know that what are the module of your LRB, what are the contents, and what is the important one for your LRB syllabus. Okay, so first of all, those who are here, please like the session and share the link of this session, and just copy the link of this session and just share amongst the Telegram, Facebook and this one. Okay, so a very good evening. So class, this LRB is basically the non-stop marathon in the English medium, but tomorrow also Praveen sir will take this marathon in the bilingual language. So you have to see both the marathon and just take a pledge that you have to score in LRB subject 70 plus marks in this one. Okay, a good evening. Exactly, Suren sir. So first of all, I just want to highlight you the important module of your LRB subject. First of all, try to understand that which module is important and you have to focus. So there are 4 modules, and those who are new in this session, do not forget to like the session and please stay with me 7 p.m. to 11 or 12 p.m. Okay, so there are 4 modules. If I talk about the important one class, so module D is the one of the important module. After that, module C is important, then module B, and then module A is important. So if you want to crack your LRB subject class, so if you understand each concept of module C and D, you can easily score 60 plus marks in your LRB subject. So that's why this session I will basically focus on module C and module D. Okay? Okay, a very good morning class. Okay, so C class, in module C and module D, module C contain 10 acts, module D contain 10 acts, module B contain the terms of the banking, and module A contain the 2 acts. What are the 2 acts? That is simple: Banking Regulation Act and the RBI Act. And what are the contents that contain in this module B? Types of borrower, types of security. These are the content of module B. And in C and D, we have to cover 20 acts. Okay, exactly. Now class, first of all, a very important, talks. I just want to say you that this is for all of you. From 25th May 2002 to till now, whatever session I have taken in the YouTube session, you all have to see that session. Why I am saying class? Because this session from 25 May to till now, it's covered the whole topic. So this is very informative information that I just want to give all of you from 25th May 2022 to till now. It means at the last of the marathon, I can easily say that we have covered all the topics of your LRB subject. So those candidates who are new in this session, please do not forget to see all the session because you have 1 day left. If I cover today at least 200 plus questions, so it means you have to cover 100 questions from 25th May to this one session. Okay, so YouTube session you can easily find in the playlist of your Officers Adda. Okay, and LRB subject 7:30 p.m. I generally take the bilingual, and 9 p.m. I generally take the English medium batch. Okay, so these 2 sessions are the YT session. So you have to cover both session, because in both session I take the different questions. So if you want to clear your all topics, so I have just given you the hint. Now it's on you that whether you are covering this or not. Okay, so Divya ma'am, Ashok ma'am, simply you have to go to the Officers Adda YouTube channel. If you want the all YT session, so you have to go to the Officers Adda YouTube channel, Playlist will be there. You have to click on the playlist, then only see from 25th May. That's it. Okay? Exactly. Yes, the recorded will be available. Sanjeev sir, I have already given you the idea. If you want the all YouTube session that I have already taken, because if you cover this one now, that is damn sure the all topics of your LRB will be finished. Okay, so this is basically the YouTube sessions I have already told you. Now, let's do the question first. The first question on the screen is that a company has to issue the prospectus whenever it wants to invite the public for. The first one is public deposit, second is share, third is debenture, and all of the above. So before starting, what do you mean by the term prospectus? This topic have taken from the Company Act. Prospectus tells about the outline of the company. Now tell me, what is the exact answer? And class, whatever question I'm highlighting here, it's totally based on the important topics of your LRB subject. So that's why before giving me the answer, you have to check it very carefully. Okay, so what is the exact answer, class? First one, that the public has to issue the prospectus whenever it's want to invite the public. So they can public deposit, shares, debenture, and all of the above. So you all are right that first one, D is the right answer. So for this question, you have to at least know what do you mean by the term prospectus, and prospectus is the important content of your Company Act. Excellent, Twinkle ma'am. Okay, next. Which of the following is, class, that is incorrect? Incorrect statement regarding a prospectus. So you have to find the incorrect statement about the prospectus. The first one is prospectus can be issued only after the incorporation of the company. The date written on a prospectus is the prima facie. What is prima facie? Prima facie is a legal term which means on the face of it. Prima facie evidence of the date of publication. Second is every application form should be accompanied by the copy of prospectus, and there are certain mandatory provisions that are to be stated in a prospectus. What is the exact answer? Prashant sir, we have to take mark on the incorrect about the prospectus. Incorrect, class. We have to find out the incorrect, class. The first one, the prospectus can issued after the incorporation. This is exactly right. Second was the date written on the prospectus is the prima facie. This is absolutely right. Prima facie means on the face of it. And the second one is every application form should be accompanied by the copy of prospectus. See the C statement. What do you think? This is the right one. C1, that every document have to be attached with the prospectus. Prospectus is just like the brochure of any company. Okay, so the exact for this one is, Dheeraj sir, you are wrong, Baba. For this one, the exact answer is every application form should be. This is the wrong answer, C1. Just see this. C is the Gitanjali ma'am. What are you doing here? Every application form should be accompanied by the copy of prospectus. This is not the right statement. Why we require the copy of prospectus in every document? So C is the right answer. Excellent, Nutan ma'am. Okay, good. Next question. If there is some misstatement in a prospectus, okay. If there is some misstatement in a prospectus and a person is induced to subscribe the share or debenture, what remedy to the said person have? And which of the following is, class, incorrect? So the question is asking about the incorrect statement. So the first one is the person can rescind the contract. Rescind means to breach the contract. The second one is the person cannot claim damages from the company. What is damages? Damages means the compensation. Next one is the person can be claimed damages from the promoters responsible for such misstatement, and the last one is none of the above. What is the exact answer? Suppose, if I go to the this one, SBI Bank. SBI Bank have given me the prospectus. So prospectus means whatever that is written in the prospectus, I have to think that everything is right. So suppose in that question if the misstatement is there, so what will happen? Third one. Excellent class. If any misstatement happen, the person can claim damages. A person cannot claim damages. So for this one class, this is the incorrect answer because we can claim damages from the promoters. Exactly. Good evening, Rohini ma'am. So the exact answer is, which of the following is not correct? So B is the right answer. Is that clear? Excellent. Good. Okay, because we can claim class, we can claim the damages, and damages means simply compensation, price money. Okay, good. Next one. In every public company, at least dash of total number of directors are to be person whose period of office is liable to be determined by retirement by rotation. 1/3, 2/3, 3/4 and 3/5. So you have to tell me that under what, what is the majority required if the director want to retire from a company. So what is the exact answer? Fourth one. And guys, do not forget to like the session because this session is very important for all of you. And tomorrow, Praveen sir will take the session in the bilingual language, and today we are studying in the English medium language. Yes, class, what is the exact answer of fourth one? Retire by rotation in a public company. So, how much this percentage required if a director want to retire in a public company? So, Meera ma'am, you are absolutely right. Class, in majority, 2/3 member required for this one. So in that case also for the director, 2/3 director will be retired in a public company by the rotational method. Okay, excellent. Now next question. Which of the following can appoint the additional directors in a company? It means who have a authority to appoint the additional director. The first one is the promoter of the company. Second is the board of director. Third is the shareholder, and the last one is the underwriter or debentures holder. So who have authority? Rajesh sir, tomorrow different will be absolutely different. No, Rohit sir and Rajesh sir, tomorrow the questions will be different. Tomorrow the questions will be different. Okay, class? Hello, Ranjana ma'am. Hello, Abhinav sir. Welcome to all. So class, what is the exact answer? Who have authority? So all of you are right that for this one, the exact answer is the board of director have a authority to appoint the additional director of a company. Excellent, class. These questions are the legal fact that you have to know. There is no actual reason that, ma'am, why only the board of director have a rights to appoint the additional, because this is a law which is made under the Company Act. That's it. Okay, excellent. Now next question. The alternative director. Oh, the alternative director in a company is appointed by. So the Newton ma'am, the first answer is promoter, second is board of director, third is shareholder, and the last is underwriter or debenture holder. What is the exact answer? It's okay, Sanjay sir. Those candidates who have missed the few questions, you can easily see in a recorded session, okay? You can easily see in a recorded session. Alternate directors. Directors means who direct the company. Director means who direct the company. So what is the exact answer? Welcome to all. Welcome to all. I think you all have come from the office, right? Dheeraj sir, Priyanka ma'am, you all have come. So for the 6th month class, you are absolutely right. The board of director is the person who have authority to appoint the alternate directors also. Excellent, class. Vipin sir, C is not the right answer. The right answer is board of director. Okay? Excellent. Now the next question. As per the SEBI requirement, Security Exchange Board of India. It is a controlling authority of the stock market in India. How many directors should be independent directors in a company? According to the SEBI requirement class, this question was asked. Okay. So the first one is 20%, C is 33%, second is 25%, and the D is 50%. Okay, it's okay. You are still in the office. What is the exact answer? Under the SEBI requirement, how many directors should be implemented? This is a simple law. I will stay in a one side because the board is this one small. So if I just come in front of the board, the question will be hide. So what is the exact answer of 7th one class? The SEBI requirement. This question you can say that that may be the out of this LRB, but it's still SEBI is the comes under your this one. Also in the banking sector, okay? So what is the exact answer? 7th one class. The exact answer is Nana. The exact answer is 7th one. D is the right answer, 50%. We are not asking about the RBI or anything. It's a SEBI one class. You have to learn that 50% director they can easily as an independent director. Independent. Okay, exactly. The one person have given me the right answer, that is 50%. Exactly. Okay, now next question, 8th one. And class, in this session I have also bring the important contents. After 10 question we will discuss the important topics, and at the last one I have also bring the penalties that you people are asking, ma'am please bring the penalty in all the sequence format. So at the last of the session we will discuss the penalty. Okay, now. So an additional director in a company hold office. So what is the tenure of the additional director in a company? And the Company Act class, that is very important. For the period he is appointed by the board, at least for 2 years and maximum for 3 years, till the next annual journal meeting, yeah, till their removal by the board of directors. What is the exact answer? The screen is class visible now? The screen is visible to all of you? First of all, please tell me. Ma'am, how long this session? Are Baba, the session is just started and you are asking, ma'am, how long the session will be? This is very a common sense question. The 8th one, the exact answer is absolutely right. The 8th one, till the next annual journal meeting, the additional director will be hold the office. Excellent. Okay, good. Next one. A person appointed as a director of the company has to send his consent to the act as a director to whom? Within dash days. This is very important. A person appointed as a director has to send his consent to act as a director. So this one tag he have to send to whom person? 9th one. What is the exact answer for the 9th one class? In the company, which is important, the company, shareholder, public through the advertisement, or ROC is important. If a person is becoming a registrar, so to whom he have to give this one. So the exact answer is absolutely right, class. D is the right answer, that is registrar of the company 30 days. You know, these topics, you know, generally in the if I talk about the Company Act, so the Company Act features are important, corporate will is important, memorandum and article of association is important, doctrines are important about the member, director, prospectus, winding up. So the company law contains so much questions. So that's why in module D, that is very important from the examination point of view. Okay, so that's why these companies questions are very important, and the 9th one, that is exact answer is D is the right answer. Good. Next one. A particular person cannot be director of more than dash companies concurrently, excluding the private companies or unlimited company. Tell me, sir, 15, 12, 20 or no such restriction. As you know that in your JIB exam, 70 question asked as a half marks. So if you want to gain 70%, this one marks question generally asks and 2 marks question also asks. So if you want all these question, so you know, if any 2 marks question comes, the concept will be same, but the line will be 8 to 10 line. That's it. So for the 10th one, exact answer is excellent class. 10th one, exact answer is C is the right answer. बहुत बढ़िया. Exactly. C, no. 15 was पहले था, but अब आप लोग का क्या है? 20 is the right answer. ना. 20 is the right answer for this one. Now, 10 question. Now we will understand the concept, because in every after 10 question I will just bring the concept in which your concept of the module will be also clear. So class, this Indian Contract Act, that is a part of your module D, it's talk about the essentials of the valid contract. Section 10 of the Indian Contract, which is very important. Section 10 is also known as the backbone of Indian Contract Act. So what is section 10? What are the essential point? Essential point of the valid contract. Suppose if any customer is coming, okay, you want to reduce the brightness. Okay, just wait. You just want to reduce the brightness. Just wait. I'm just calling the person who will do this. Okay. Just wait, class. Now it is okay? Now it is okay, class? एक बार यहाँ आना दिशु. Now it is okay? Brightness? Okay, just wait. I have just called the person. It is not okay. Okay, I will just tell all the topic, okay? Don't worry, I will tell all the topics. Don't worry, okay? Don't worry. Okay, so section 10 of the Indian Contract, I will tell you what is exactly that is written here. The first one is that for every valid contract class, there must be 2 parties. For every valid contract class, there must be 2 parties in the valid contract. So that is the first point. The second one is, class, in valid contract, there must be the legal relationship between the person. Okay, there must be the legal relationship between the person in the valid contract. The next one is fulfillment of the legal formalities. What is this? Fulfillment of the legal formalities. I'm just writing, class, so please focus on the board. Brightness कितनी है नहीं दिख रहा है क्या? सेशन चल रहा है. Okay, class. So the first point is 2 parties. The second is the legal relationship between the person. The next is the legal formalities. The next one is there must be the certainty of the meaning. It means if any contract is going on, so there must be the concept should be very clear. Okay, the concept should be very clear. Class, don't worry, I'm just writing these all point here. Don't worry. There must be 2 parties for the valid contract. Second one is there must be the legal relationship. There must be the legal formalities between the person. Legal formalities, okay? Certainty of the meaning. Certainty means, suppose if I ask the shopkeeper to give me the 10 kg of rice, so 10 kg rice means that is not the clear meaning. If I say that 10 kg of basmati rice, then the meaning is clear. Now it is called the valid contract. Okay? The next one is called possibility of the performance. Just listen what I am saying. Okay? So what is possibility of performance? Possibility means suppose if any contract is done between me and Swati ma'am, so it must be the possible. Suppose I say to Swati ma'am, please bring the star for me. So bring the star for me, that is not possible. So that's why the impossible thing cannot be converted into the valid contract. Okay? The next one is there must be agreement between the parties. What is agreement? There must be the legal agreement, not social, not religious, not domestic agreement, but there must be the legal agreement between the parties. The next one is class free consent. In contract between two parties, there must be the free consent between the party. What is free consent? Free consent means without any pressure, the party have to enter into the contract. The next one is competency of the party. If any person want to do any contract class, so the party must be above 18. Party must be sound mind and the party must not be disqualified by law. That is called competency of the party. And lawful consideration. As you know that class, for every valid contract, there must be the lawful consideration. What is lawful consideration? Suppose I ask Swati ma'am, please do this work. I will give you 10 kg of heroin. Heroin means drugs. So drugs is the unlawful. So unlawful consideration will not convert it into the valid contract. The next one is legal object. In every contract, there must be the legal object. And the last one is not expressly declared to be void. It means any contract must not be declared void by the person. Okay. So these are the important concepts. Question can be asked in any form by these concepts. Any doubt in this concept? Class, any doubt in this concept? First of all, tell me, any doubt? So these are the, any doubt class? Because this is very important concept. These all point cover the general principle of contract topic. That's it. Midas does, sir, lawful object means suppose we are doing the contract and you are saying that Nikita ma'am, if you murdered that person, I will give you 10 lakh rupees. So murder is the lawful or unlawful object? That is unlawful object. Okay. So that is called, so these are the important contents. Okay. Now cool. Special principle of contract, that is important. What is indemnity? Indemnity means all insurance example will be come under the contract of indemnity except life insurance. This is very important. In insurance class, one party is, two parties are there, X and Y. In every contract, there must be two parties. So in contract of indemnity, suppose if I purchase the car and I just insured my car. So whatever damage that will happen to my car, the car insurance company will be liable. That is called contract of indemnity. That is called contract of indemnity. Papia Mitra say, ma'am, can a minor enter into contract? No, Papia sir, the minor cannot enter into the contract if any agreement done by the minor that is void ab initio. That is void from the very beginning. Okay. So class, in that case, suppose Nikita ma'am have purchased the car. So Nikita ma'am is called the indemnity holder and this Y person, the car insurance company will call as the indemnifier. Its name is indemnifier and Nikita ma'am is indemnity holder. Okay, exactly. Now, what is contract of guarantee? The contract of guarantee class, that is simply, this is principal debtor, this is creditor and this is surety. So according to the principle of guarantee, creditor will give money to the principal debtor will take money and surety will be there who will take guarantee on the behalf of principal debtor to the creditor. That is called contract of guarantee. That is called contract of guarantee. So these are the three portions of contract of guarantee. Okay. Now, what is bailment? Bailment means A person is there and B person is there. Suppose A had given TV for repair to the B person. So A person is called as the bailer and B person is called the bailee. So in that case, class, the bailer has given the movable goods for specific purpose to the mechanic. After 1 week, when the TV get repaired, so bailee give back to the bailer. And bailer had also given the consideration that process is called contract of bailment. That process is called contract of bailment. SD sir, section 10 is the backbone of Indian contract which talk about the valid contract. Okay, exactly. Bailment, two parties is there, bailer and bailee. That's it. Okay, exactly. What is pledge? Pledge means class, A person is there, B person is there. Suppose A person had given 10 lakh rupees to A person and A person is giving movable property as a security. A person is giving movable property as a security, that is called pledge. That is called pledge, in which movable property was going to this person. So in that case, A person is called pawner and B person is called pawnee. Okay, exactly. And the last concept is contract of agency. So the contract of agency, basically X person is there, Y person is there. Y person is always doing work under the guidance and direction of this X person. So X person is called the principal and Y person is called the agent. So this is called contract of agency. The relationship between principal and agent is called contract of agency. Okay, exactly. Exactly. Okay, so this is the important segment of the Indian Contract Act. Now let's do question, class. This is the case study question. This is my format. After 10 question, we will discuss one concept and one case study question. Okay, now no, you do not have to mug up this section, class. You do not have to mug up this section. No need to mug up the section. Sections are only here. In your LRB exam, only 2 to 3 questions come as a section base. So no need to. Okay, exactly. So class, XYZ Limited Company borrowed some money from Mr. A by issuing a bond. Okay. The article of association. What is article of association? It's talk about the internal management of the company. That is called article of association. Provides that the director can borrow as much as money they want. It means in AOA, this is come. This is written. Okay. Now, the shareholder claimed that they did not pass any resolution. So you have to tell me 4 options are there. The first one is the borrowing has become ultra virus. A cannot recover because application for doctrine of constructive notice. C is funds lent by A are safe because application of indoor management, and funds lent by A are not safe because this cannot be ratified by the shareholder. What is the exact answer? This is very good question. The article of association is basically means there is a internal management of the company, rules and regulations are written, that is called AOA. Doctrine of indoor management. Doctrine of indoor management means please listen very carefully. Indoor management means, suppose if I want to do business with Swati ma'am company, in that case Swati ma'am, suppose the Swati ma'am company have given me the MOA and AOA. I had just read all the things of this MOA and AOA. Now Swati ma'am's company have changed something in the AOA. That knowledge Swati ma'am have not given to me. So in that case, class, in that case, I will be not liable if any mishappen done. Swati's ma'am company will be liable. So this process is called contract of doctrine of indoor management. Exactly. So all of you are right, class. That is the funds lent by A are safe because application of doctrine of indoor management. It means if everything is written in the AOA, AOA had given, this right to the directors. So that's why this C is the right answer. Exactly. Excellent, Isha ma'am. Indoor management give protection to the outsider. Okay, the company will be liable if company have changed something and you have not given knowledge to the outsider person. Excellent. So for that thing, class, C is the right answer. These questions are called case study question. Your 2 marks question will come in that form. Your 2 marks question will come in that form. So that's why this is very important. Okay, now, which of the following is the class objective of FEMA? So I think class you are liking the concept. After 10 question, I will give you one concept, and after that case study question, then again questions. Okay? Venkat sir, don't worry, I will explain all the doctrine. Just wait, yaar. Just wait, Venkat sir. Okay? So now class, which of the following is the objective of word FEMA? First option is to facilitate trade and promote orderly development of forex market in India. Second is to facilitate the external trade and payment and promote the orderly development of forex market in India. C is to facilitate the external trade and payment and promote orderly development of forex market. Facilitate the external and forex market. And the last one is to replace the Foreign Exchange Management Act and to promote the orderly development of the forex, this one. Yes, class. What is the exact answer of 11th one? 11th one, what is the exact answer? Just tell me the objective, yaar. Objective is very easy. Objective is very easy. So for the 11th one, excellent. For the 11th one, class, B is the right answer. This is the objective of the word FEMA. What is FEMA? FEMA means India is a developing country. I think बचपन से सुनते आ रहे हैं India is a developing country. So developing अभी तक develop नहीं हुआ. Why? Because I think we are मतलब बहुत पीछे हम लोग साइंस से, इसीलिए तो इंडिया अभी तक डेवलपिंग कंट्री ही कहला रहा है. सो इन दैट केस द एक्सचेंज ऑफ दिस मनी फ्रॉम डॉलर टू रुपीज, रुपीज टू पाउंड, if we want to do trade from the outside company, so we need a foreign currency. So that thing will be handled by the FEMA. Excellent, class. Okay, so 11th one, B is the right answer. This is the objective of the word FEMA. Excellent. Welcome, Surinder sir. How are you? Next, the term authorized person, that is very important term of your FEMA. Under the foreign exchange means authority, authorized dealer only, authorized money changer only, authorized dealer and authorized money changer, and authorized dealer and authorized money changer and other institution. Exactly, Shubhangi ma'am. So what is the exact answer, class? The authorized person means an authorized person, class, always appointed by the RBI. RBI always appoint the authorized person. Now tell me the exact answer of that one. And class, please do not forget to like the session and please copy the link and share it in the social media. Please, class. So what is the exact answer of 12th one? You are absolutely right, class. This authorized dealer and the authorized money changer will come under the authorized person, and this is always appointed by the Reserve Bank of India. Okay, excellent. Now the next one. Next question. Under the FEMA Act, class, the license to operate as authorized person is granted by RBI only in case of bank, SEBI only in case of institution, या DGFT in case of money changer, या RBI for all. 13-1. RBI for all. I have just already given you the hint in the 12th question. If you just go on the hint, you can easily do that question. You can easily do that question if you just if you just remember the hint of 12th question. Excellent class. The answer is RBI for all is the right answer. Always remember, the authorized person always appointed by the RBI. Okay, good. Next question. Next question. Which of the following is not a capital account transaction? That is very important. Capital account transaction, current account transaction, authorized person. I will explain this concept because I have also bring this concept in this one slide. So first of all, you have to tell me these are the example. So which of the following is not a current account transaction under the FEMA Act? Hello Aditya sir. So import of capital goods by India company. Second is change in the asset apposition outside India of a person resident in India. Third is change in asset or liability position in India of a person resident outside India, or none of the above. And class, I will explain this concept in this session. After I think 20 question, the concept will become. I will just give you the small trick to understand what is current account transaction and what is capital account transaction. I will give you a hint. Okay class, I will give you absolutely hint. Exactly Rohini ma'am. So the 14-1 exact answer is, you are absolutely right. A is the right answer. In the concept, I have bring these concept. Okay, so just wait for what is the formula to learn the capital, current and authorized person. Okay, excellent. Exactly. Okay, now next question. As per the FEMA Act class, which of the following cannot be included in the foreign exchange? The first one is amount payable in foreign currency. Second is draft and traveler check drawn in India. C is draft and traveler check drawn in outside India but payable in India currency. Yeah, none of the above. Cannot be included class. Cannot be under the FEMA. Excellent Amrinder sir. If you have learned the formula, that is very good. Otherwise, I will give you a tips how to learn current account and this current and capital account. So what is the exact answer that class under the FEMA? Because you know, of each act, the definition terms are very important. Of each act, definition terms are very important. So that's why under the FEMA, the all definition terms are very important. So what is the exact answer of 15-1? So you are absolutely right class for the 15-1. D is the right answer. Excellent class. D is the right answer, that it cannot include all of these things. Okay, good. Next one. Under the FEMA Act class, a person is defined to include which of the following? Individual or Hindu undivided family, firm or a company, association of person or body of individual, yeah, all of the above. What is the exact definition of a person that's defined under the FEMA Act class? 16-1. That is so easy. 16-1 class. 16-1, what is the exact answer under FEMA? The person is defined. And class, if it is possible, just stay with me because the questions are very important and your time is also very crucial, very precious. Okay? So for the 16-1, you are absolutely right class. D is the right answer. The person include all the things. Excellent class. Next one. A person resident in India, if he reside in India for dash, how many days? And in the dash year. This is very important question. Exactly. What is the exact answer? How many days class and what year will be called? Preceding financial year, preceding the first option is at least 180 days, preceding financial year. Second option is more than 182 days preceding financial year. Third is more than 182 days current financial year, or last is at least 182 days preceding the calendar year. This is the simply legal fact question, class. Legal fact. What is the exact answer? Excellent. You all are very okay. Now 160 days is not the right answer. 17(1). It's a more than, class, 180 days and preceding the financial year is the right answer. Okay? Exactly. So this is the right answer. 17(1). B is the right answer. Next one. If there is any contravention, okay, if there is any contravention, what is contravention? That is inconsistent of the provision of the FEMA Act, class, it attract the penal provision. So appeal can be made under what person? RBI, Directorate of Enforcement, Special Director, या Civil Court? Class 18 question is, if there is any contravention, contravention means any inconsistency. So what is the exact answer of class 18(1)? To whom, class, we will appeal for this one? To whom, class, we will appeal? 18 question. Okay, Naveen sir, I will repeat 15 question. Just wait, Naveen sir, I will repeat. What is the exact answer of this one? 18(1). To whom we will appeal? Why you people are saying Directorate of Enforcement, class? This is not the exact answer. The main work of ED is to investigate the matter, power and seizure. B is not the right answer. B is not the right answer. Why you people are saying B? Baba, ED is the different one. ED also comes under FEMA, but the work of ED is different. The appellant authority is different in this one. It's a special director. Excellent, class. Special director is the right answer. Those candidates who are saying, ma'am, please, you know, Hindi word, I cannot use Hindi words. It's a totally English medium. You only have to see the question. That's it. No, Rupesh sir, I cannot speak in this one Hindi. Tomorrow, the session will be there. Okay? Exactly. Next one. If amount is, this is the question of penalty, class, that is very important. Question of penalty under the FEMA Act. If amount is not quantifiable, quantifiable means that is not calculated. That is not calculated for a contravention, the penalty under the Foreign Exchange Management Act is up to 50% of the amount involved, equal to the amount involved. C is up to 2 lakh and up to 5 lakh. What is the exact answer? What is the exact answer, class? The amount is not quantifiable. Quantifiable means that cannot be calculated. That cannot be calculated, class. That cannot be calculated. You are absolutely right. C is the right answer. Up to 2 lakh, the compensation will be there. And penalties slide I also bring in today's session. At last of this session, I will show you the penalty in the sequence way. Okay? Exactly. Next question 20. Where a contravention is continuing. Okay, the contravention means, class, the inconsistent thing is continuing. Further penalty under the FEMA can be, what can be the further penalty, class? The first option is ₹1,000 for every day after the first day. Second is 2,000 for every day after the first day. C is 5,000 for every day after the first day. And the last is 10,000 for every day after the first day. What is the exact answer? If it is quantifiable, sir, then thrice the money. Okay? So what is these are the, a penalty based question under the FEMA Act, Prevention of Money Laundering Act, I think in the IT Act, question will become under this one penalty also. So what is the exact answer of 21? So you all are right for the 21. C is the right answer, 5,000 at the every day. Excellent class. Good. Okay. Now again, concept. Types of partner. This is very important. What is the types of partner? First of all, types of partner, this is taken from the Indian Partnership Act 1932. This is the act name. What are the types of partner? First of all, we have to understand what is partner. Suppose X person is there, Y person is there, Z person is there. They are the partners of the firm. Okay? They are the partners of the firm. So under the Partnership Act, if any act is done by X person, if any profit is done, profit will be distributed among all. Or if any loss is done, so loss will be bear by all. That is called the partnership firm. And partnership firm have not separate legal existence just like the company. Okay? Partnership is just like, if the partner's gone, partnership firm will be dissolved. So, okay? So the partnership firm will exist because of the partners. Okay? I think you understand the term, this one, partnership. Now, what are the types of partner that can come into this picture? So, if we talk about by the age, major and minor. This is very important. Please see it. Okay? If we talk about the major class, so every partner is above 18. Whatever the person that's come into the picture, so every partner age should be the major. It means plus 18 person can become the major. And if we talk about the minor class, so this segment is very important if we talk about the minor. And please listen it very carefully. If we talk about the minor, so first of all, minor cannot become the partner in the firm. Minor cannot become the partner in the firm, but if the minor become partner, he can always take the profit from the firm. He will be not liable if the partnership firm in loss. There is a one thing that's in section 30 of the Partnership Act which talk about class. If any minor is there, if any minor is class partner, so after attaining the age of majority, suppose this minor is 16-year-old, if the minor attained the majority, that is 18-year-old, so according to class section 30, what it talks about, after attaining the age of majority, the minor have two options. The minor have two options. The first option is the minor have to give public notice that within 6 month class, within 6 months, the minor have to give public notice that I want to become the partner. This is the first option. The second option is if the minor will not give the public notice, so after completion of 6 months, the minor will be assumed as the partner of the firm. Exactly. Okay, so this is very important about the minor. So you can easily, do the questions by understanding the section 30 of the Partnership Act. And if you want to go in a detailed class, so please check section 30 of the Partnership Act, which is the exact wordings of the word minor. Okay, exactly. Now we have done this one. By the liability, the partners are mostly unlimited. The partner's liability is unlimited. Always remember that. If we talk about the types of partner under the activity, so the partner can be active. Active partner means who actively participate in the partnership firm. The second one is dormant partner. Dormant partner means the sleeping partner is called dormant partner. Nominal partner means the partner who will give only the name, that is called nominal partner. And the last one is estoppel. What is estoppel? Estoppel concept is also very important, the term estoppel. Estoppel means if any partner, suppose XYZ is the partner in the partnership firm and they generally do business with this person, A person, okay? So suppose there is an entry of this person in the partnership firm. He is a new employee in the partnership firm. Suppose X told to A person that B is also our partner. After listening this, A generally do business with the B person. So now suppose if any loss is done between A and B person, so for that loss class, everyone is liable. Why? Because he is also the partner. Now in that time class, the X person cannot say that I didn't have say these words. He cannot say that thing. Okay? Exactly, Sanjay sir. See, minor always take the benefit, but minor cannot be personally liable. We can suppose if the minor have taken 10 lakh rupees from me, so I can take my 10 lakh from the property of the minor, but I cannot, take it by the personally from the minor. This is very important. Okay? Exactly. So now the next one is new partner. If any partner is entering, so that partner will be liable for the partnership firm the day he enter into the partnership firm. What is retirement? The person who is going from the partnership firm, that is called retired partner. And what is insolvent? Insolvent means the partner who have nothing, and this insolvency should be declared by the court. If any partner is saying I'm insolvent, so that will not assume as an insolvent until the court will not say. And what is deceased? Deceased person means the partner who is dead. That is called deceased person. For the retirement class, the public notice is also required in the retired partner. That's it. Okay. So this is all about class, the types of partner, which is very important. Now, dissolution means end of the partnership. This is the important concept. Exactly, Mahi ma'am. Retire means outgoing partner. Exactly. And Mahi ma'am, if the partner is dead, no need to give public notice. That is, the people will assume. Okay? Now, how the partnership firm will be dissolved? So, dissolve means end. It can be done by the agreement. It can be done by the compulsory dissolution, and no need to remember the section. It can be done by happening of some event, and it can be done by giving the notice. Dissolution of notice always done under the partnership who is created by will. This is important one class. If the partnership is, if the partnership is done by the notice, dissolution is done by the notice, so it will always done under the will. And the next one is dissolution partner by the court. So it means dissolution of partnership will be always done under two categories, with the intervention of the court and without intervention of the court. Okay, so this is very important. So you can easily see the concept of these dissolution. Okay, this is very important. Now, case study question. Now the first question on the screen is that partner A of ABC firm. Partner A of ABC firm wants to file a suit against partner C and B, okay, of the firm, and for his share of profit, but the firm is class not registered. The firm is not registered. In a partnership firm, 3 partners are there. One partner is filing a suit on other 2 partners, but the firm is not registered. The next one, he also planned to file a suit for dissolution of the firm. So class, you have to tell me that which one is not correct from the following point. The first one is he cannot file suit on ABC. Second one is he cannot file suit on A and B as a partner. He cannot file suit for dissolution of the firm, and all of the above is the correct one. Tell me class, this is a case study question that is very important. Shweta ma'am, estoppel means whatever I have committed, I have to stick with my words. That is called estoppel. If I talk about class, the registration of the firm, so the registration of the firm is optional. If the firm is registered, it have a benefit. If the firm is not registered, so there are so many consequences of the non-registration of the firm. So what is the exact answer? Yes, class. This is the case study question, and the case study question, 15 question will come as a case study one. So which of the following is the exact one, class? That whether you have to tick mark on the not correct. So the option is A cannot file a suit on ABC. Second one is A cannot file a suit on A and B as a partner. C is C cannot file suit for dissolution of the firm, and the last one is all of the above is correct one. What is the exact answer? Yes. What is the exact answer, class? And the question is the firm is not registered. The firm is not registered. Excellent, Mahi ma'am. He cannot file a suit on ABC. This is right one. He cannot file suit on this is right one. He cannot file suit for dissolution of the firm. That is right one. So which of the following is this one exactly? He cannot file a suit for dissolution of the firm. Holding partner, Monica ma'am, that is same as the estoppel partner. Same as the estoppel partner, sir. So what is the exact answer? You have to tick mark not correct. Not correct, class. Sagar sir, if the firm is not registered, na, A cannot file suit. This is exactly right. A cannot file suit on A and B as a partner. This is exactly right. A cannot file suit for dissolution. This is exactly right. All of the above is correct. Exactly. So the answer should be D is the right answer, because a non-registered firm cannot do anything. A non-registered firm cannot do anything. These are the consequences of the non-registration of the firm. Okay. Now next. 21 question, class. 21 question. If a suit is to be instituted, what is suit, class? Suit means simply case. If the case is to be instituted under the Transfer of Property Act for sale of mortgage property, so which of the following, class? That is not correct. Not correct. The first one is suit can be instituted of the court of lower jurisdiction where it can lie. Lie means jahan pe hai. The suit can be instituted in the jurisdiction of the court where property is located. Third is, in a civil court, the decree is twofold, that is conditional and unconditional, and all of the above situation is correct. You have to tick mark which of the following is not correct. Not correct, class. Which of the following is not correct? Yes, this question is of TP Act, class. TP Act. TP Act, mortgage. Mortgage means in which the immovable property is taken as a security. So for the 21 class, the exact answer is C is the wrong answer. C is the wrong answer. So that's why we have to tick mark on the not correct. So this is not correct. So that's why C is the right answer. We can exactly file the case where the court is instituted and where the property is located. This is the right statement of this question. Okay. So C is the right one. Good. Next question. In the case of suit means again case for the sale of mortgage property under TP Act, the preliminary decree what is preliminary decree? Decree means judgment, and preliminary means before final decree, whatever the order which is given by court, that is called this decree. Okay? So what is the exact answer? Condition to be fulfilled by the bank before sale, condition to be fulfilled by the debtor before sale, time limit given to the mortgagor to pay the decretal amount, and time limit given to the mortgagor and mortgagee to reach a compromise. What is the exact answer of 22nd class? In a case of suit for sale of mortgage property and the TP Act, the preliminary decree, what is preliminary decree? Before final decree, it means before final judgment, if any decision is taken by the court, that is called this one. So what is the exact answer of 22nd class? 22nd, the exact answer is the exact answer is, you are absolutely right. Those candidates who are saying that 22nd, C is the right answer class. Time limit given to the mortgagor to pay the decretal amount. What is decretal amount? The amount which is, said by, order by the court to pay. That is called decretal amount. Excellent class. C is the right answer. Sabash. Next. In case of lease. What is lease? Suppose my room is there. I have just given my room for the rent to the another person as a possession. I have just given the possession. So lease is for basically permanent possession and license is for the temporary possession. So in the case of lease class, the right of dash of the immovable property is transferred to the leasee. The first one is ownership only, use only, possession only, या use and possession only. What is the exact answer? Decretal amount is just like the remaining, but it is simply the amount which is decreed by the court. You can just assume in that way. So what is the exact answer? What is the definition of lease class? Lease. If I given my home as a rent to you people, you are only saying C. Answer will be from this and this class. What is the exact answer? I have already told you the concept of this lease. What is the exact answer? Class for 23-1, the exact answer is we can use and we have a possession of the property. So D is the right answer. Exactly. So if the two words are written class, so you have to tick mark on the use and possession. So D is the right answer. Excellent. Next one. In actionable claim class is secured by pledge, hypothecation, mortgage, or no security. Before starting this question, I just want to explain you what is actionable claim. The actionable claim is basically class claim to unsecured debt. The meaning of actionable claim is claim to the unsecured debt. And next one, beneficial interest in movable property. That is called actionable claim. Please remember this definition, that is very important. No, Rahul sir, 24, not all is the right answer. 24, what is the exact answer of 24? I have already told you actionable claim means claim to the unsecured debt. And the last one is beneficial interest in the movable property. Suppose if you have given me the movable property, I have already given you the money, but you are not giving me the possession of that property. So that is called, I can claim, I can just file a sue on you. That is called actionable claim. So what is the exact answer for this one? Excellent, Suman Saurav sir. D is the right answer. Your answer is written. I have already written the definition of actionable claim. So you can easily guess no security is the right answer. Chitra ma'am, 24. D is the right answer, Baba. In pledge, hypothecation and mortgage, the security is there, na? And what I have written, class, the actionable always claim on the unsecured debt. And these all three are secured debt. So that's why D is the right answer. Okay, good. Next one. A loan with a limitation period is 3 years was granted on July 12, 2016. 12 July 2006. If the limitation is with reference to the date of document and the court is closed from July 10 to July 12, 2009. So class, the suit can be filed by Suit can be filed by 11 July, 12 July, 13 July or at the discretion of the bank. Discretion means will of the bank. What is the exact answer of class 25th? As you know that limitation period means that what is the time limit under which we can file the case. So if the limitation of this is from 12 July, so just count 3 years from 12 July. But in 12 July, the court is closed. So under which date we will file the case? Under which date, class, we will file the case? So we will file the case. You are absolutely right, class. 12/25 C is the right answer. If the court is closed, so we can file the case when the court is open. Excellent, class. Good. Next. It's a banking. Banking ombudsman settle the dispute between two customer, between customer and bank, between two bank and between customer and bank, or between customer and government. Exactly, class. And class, yesterday in the YT session, I have taken the class of RBI Integrated Banking Ombudsman 2021. So please do not forget to see the session. Yesterday at 9 PM in the YT session, I have taken the new amendment act, that is of Integrated Banking Ombudsman 2021. Do not forget to see the session. So for the 26th one, the ombudsman always handle the case between the customer and the bank. So B is the right answer. Excellent. Good, class. Next one. What is the minimum paid up capital for the private company, class? 1 lakh, 5 lakh, 10 lakh, or there is no such restriction? Nana Ankur sir, I have already done the Integrated Banking Ombudsman in the yesterday's class. What is the exact answer of class 27? What is the minimum paid up capital for the private company, for the public company? You have to know. You have to know. (26) is absolutely right between the customer and the bank. Who is saying wrong? Are Baba, 27(1) D is the right answer. You know, class, law can never be stable. It have to be changed. So before it was 1 lakh, but now there is no such restriction. But now there is no such restriction, class. In the previous, you know, the Company Act 1956 was the first act. 2013 is the new. So that's why in the amended and in 2015 also, there are so much change that's come under the Company Act. So now there is no restriction in the public as well as private one. Exactly. Okay, good. As regard the public issue, a private company, first of all, think that the private company can issue this one. Cannot invite public to subscribe to share, but it can invite subscribe to the debenture. Second option is it cannot invite the public to subscribe to the debenture, but it can invite to subscribe the share. Third is it can invite public to subscribe the share and debenture. And the last one, it cannot invite public to subscribe the share and debenture. What is the right answer? Okay, Kaushal sir. 17th question, 182 to 120. Okay. I will see. Kaushal sir is saying the resident days is also changed from 180, now it is 120 days. Okay, sir. Excellent, Mahi ma'am. So what is the exact answer? It is all about the private. So as we know that the private company, if they want to do this, they have to be first of all mentioned in the article of association. Right? So for the 28th one, you are absolutely right. They cannot invite public to subscribe the share or debenture. Excellent class. It is only for the public company. Public company can easily subscribe it. Excellent. Next. What is the minimum paid up capital for the public company? Again that question. 1 lakh, 5 lakh, 10 lakh, or there is no such restriction. Imran Sheikh sir, PPB 25% cover under this one. Okay, Amit sir. Okay. So it is amended. Now 182 days is not 122. 120 is the latest one. Okay. PPB question, 25% PPB syllabus cover under the LRB Act. Okay. So this is not the repeated question. So what is the exact answer, class? D is the right answer. Excellent. Good. Next one. In the case of government company, minimum 51% share should be held by central government, state government, partially by central and state government, or any of the above. What is the exact answer? What is the exact answer? 31 class. Government company minimum 51% share should be held by, what is this? 30 question. In the case of government company, class, government company means that much percentage they have to hold from the other company. So what is the exact answer? 31 class, 30, exactly 31. D is the right answer, class. D is the right answer. It may be central, it may be this one. Okay, 31, 30 is D is the right answer. Excellent. Okay, next. Now the concept. Again now class, concept under the Sales of Good Act. What is the difference between sale and agreement to sale? This is important topic. This is important topic. Exactly. Sale means, in one word I can written it, present sale. And agreement to sale means, class, future sale. This is very important. Present means, suppose I am giving this pen to the Shubhangi ma'am. Immediately I am transferring my ownership to the Shubhangi ma'am. That is called sale. But agreement to sale, I am just saying, Shubhangi ma'am, after 10 days I will give this pen to you. That is called agreement to sale. That is called agreement to sale. The nature of sale is absolute because we have already transferred the property. Ownership is already transferred. In this one, it is conditional because it is depend upon the future thing. Something is remaining to be done. It is executed. Executed means done. ED, that is a past tense. And it is ORY, future. Something is remain to be done. Exactly. Transfer of risk take place immediately, as we know, and transfer of risk doesn't take place until unless the goods are transferred. Now, the right to sell remain with the buyer because the property is already transferred. So that's why the right is with the buyer. But in this one, the right is with the seller. So this is the basic difference between sale and agreement to sale. Okay, Ashish sir is saying, ma'am, it is updated on 31st/12/2021. So Ashish sir, is depend upon Verma sir. Absolute means totally. Suppose this is the pen. I have only given you this one. This is not the absolute. If I give this pen total, that is absolute. Okay? It means completely. Completely. Suppose my bike is there. The cost is 1 lakh. I have given you the fully bike and you have given me the 1 lakh. That is absolutely transfer of the bike. Okay, so this is the basic difference between class sale and agreement to sale. I think the concept is clear to all of you. Next one. Condition and warranty, that is very important. First of all, see. First of all, see this, the definition, what I had written there. After that, I will explain this. Please read the concept, then I will explain what it exactly means. See class, condition, first of all, see the definition because sometime definition also come in your exam. Okay? So, condition means simply, it is a stipulation that is fundamental to the main purpose of the contract. One question always come from the Sales of Good Act. So condition means, suppose if I demand, see, if I demand the bottle from the shopkeeper, just give me the water in which I can contain the hot water. Suppose the shopkeeper have given me this one. Shopkeeper have given me this bottle, hot water bottle, so I just contain the hot water, this one. But when I just pour the water in this bottle, the water become blast. So in that case, class, I have a right to breach the contract. I have a right to simply refund. I have a right to just demand the refund from the shopkeeper. That is called condition. And what is warranty? Warranty is simply in which we can only replace the thing. Suppose if I purchase the mobile, and suppose the battery got damaged. So in that case, if the battery got damaged, so it means I can only replace the battery, not the mobile. That is called warranty. So I think definition is clear to all of you what is the exact meaning of condition and warranty. Isn't it? Now, next one. This is the case study question again. Case study questions. A telegraphed B, will you sell your house? Telegraph the lowest cash price. B also replied by the telegram, lowest price for the house is rupees itna. So just tell me class, whether it is complete agreement, complete contract, no contract or voidable contract. What is the exact answer? What is the exact answer of this one class? This is totally a case study question, 2 marks question. Voidable contract means in contract 2 parties are there. In voidable contract, one party have a right to breach the contract. That is called voidable contract. So tell me the class exact answer of this one. What is the exact answer of this one class? Yeah. Complete agreement. Ambrish sir, in this question, A telegraph B, will you? So tell me, in the offer, the offer always come in the question form, or it is the final willingness of the offerer? So for this one class, this is complete. The offer is not the actual offer. This is the question, and the second part is also the replying. So the question answer format cannot be converted into the contract. So that's why there is a no contract between the parties. Exactly. The first person is asking the question and the second person is simply replying the question. So that's why no contract is done. No, Shubham sir, contract may be in the written and oral in both form. It is not this one right that contract is always in written format. No, contract can be written and oral both. So in that case, there is a no contract because this is not the offer and acceptance. This is the question and answer. That's it. Okay, good. Next question. The permitted scope of activity of a company can be verified by a bank by going through the Memorandum of Association, Article of Association, Memorandum and Article, and Certificate of Corporation. 31 class. The permitted scope of activities can be verified through only Divya ma'am, voidable contract, suppose this is gun. Okay, with a gun I am just demanding, Divya ma'am, please give me 5 lakh rupees. You have given me 5 lakh rupees and I have just, you signed the document and I also signed the document. It means the document is the authenticate one. But after that, you have a right to go to the court, na ma'am. So it means only one party have a right to go to the court. That is called voidable contract. So for this one, 31 class, what is the exact answer? 31. The exact answer is Memorandum of Association. What is Memorandum of Association? That is simply a document, a very important document which talk about the 6 clauses which every company have to fill. So for 31 class, A is the right answer, permitted the scope of activity of the company. So we have to write the object clause in the Memorandum of Association. So that object clause is this question. Okay, excellent class. Next. Which of the following class that is not a correct statement in the context of the name of the company? Company cannot have a name which is in the opinion of central government is undesirable. Second option is company cannot have a name which is too identical or similar to the name of existing company. A public and private company shall use the last word of their as limited. There cannot be name of the company without the use of word limited. So it is all about the class name clause of the MOA. Now tell me what is the exact answer. Prashant sir, it's a name clause, object clause, liability clause, subscription clause, and something 2 or these there. 6 clauses are there. Liability, object, name, subscription, and 2 more are there. So there are total 6 clauses in this one, Memorandum of Association. So what is the exact answer of 32 class? 32. You have to tick mark not correct class, not a correct statement, not a correct. This is the right statement. Company cannot name, this is right statement. Public, private, limited shall use the last word as a limited, this is right. So D is not the correct one, so D is right one. Exactly, D is the class right answer. Okay, exactly. Next, 33. Which of the following is the important feature of the object clause in the Memorandum of Association? So which is not the correct about the object clause? Exactly. It's a, let's revise this one. Name clause, liability clause, it's a object clause. Next one is, it's a registered clause. Next one is subscription clause. And the last one is registered हो गया, object, liability, name, and the one is remaining class. What is one? What is the one answer? What is the one? And in this question also you have to tick mark which is the not correct. Not correct. Surinder sir, in 32 it's talk about the name. Yeah, it's a capital clause. Exactly. These are the 6 clauses. Excellent. These are the 6 clauses. I just skip this. Okay. These are the 6 clauses. Exactly, Chetna ma'am. Prashant sir, subscription and association clause is same. Okay. So class, first of all, tell me this one, the object clause of this, which is not the correct one. 33. Choice of objectives is within the initial subscriber, the memorandum of this one. A company has a main objective as well as objective, yes. Carrying on any other business outside the scope of object clause is unauthorized, called caveat emptor. So this is correct one, C1. And none of the above. Just focus on class C1. This is the correct one. Outside the scope of this one. This is correct. 33. 33 class, C is the exact answer. This is correct. Class, if the question is asking not correct, na, so please read all the option, and if you are thinking this is correct, just say yes, correct. Yes, this is correct. This is not correct, so this is the right answer. Exactly, Simranjeet ma'am. Next, the capital clause of the company should indicate, and class, MOA and AOA is very, very important. Exactly, Anand sir. C is wrong, so that's why it is right. Exactly. So class, it is all about the capital clause of the company, the amount of authorized capital only, and you have to tick mark capital clause what indicate. So you have to tick mark the right one. The number of share must be given, the face value of share only should be given, and all of the above should be given. So what is the exact answer of 34? This is very easy. This is very, very easy. 34 class. Capital clause indicate all. Exactly. This is the right answer. All of the above is correct about the capital clause of the company. Exactly. Okay. Next. The article of association. This is basically in which the internal management of the company is defined. Contain which of the following information class? The first one is registered office clause of the company. Second, set of rules, regulations and bylaw made by the company for internal management. Guidelines by registrar of company relating to filing of particulars and borrowing power of the shareholder of the company. Which of the following is right? Exactly, Isha ma'am. The board is so small. Anup sir, the class will be go on at 12 a.m. Class, it is better if you see all the question, because tomorrow Praveen sir will bring more other questions. So just see the session of Praveen sir tomorrow, and this one today, see the session of this one. So for 35 one, you are absolutely right. B is the right answer. It's talk about the set of rules and regulation, AOA. Excellent class. Good. If the public company does not frame its own article of association, this is very important, it can adopt dash that will deem to be article of association. This thing you have to learn, in which table and schedule the company can taken as an article of association. No, Vishal sir, I don't want break now. I will take break after 2 hours, okay? It's only अभी 1.5 घंटा हुआ है, आप लोग क्यों परेशान हो गए? अभी तक मैं नहीं थकी, 2 घंटे बाद ब्रेक लेंगे, ओके विशाल सर? So what is the exact answer? This is the legal fact that you have to know. In which schedule or in which table the public company suppose not frame the article of association. So this contain the article of association. So what is the exact answer of 36? 36 class B is the right answer. In table A, article of association the public company can take. You have to remember. 9 बजे break, okay चेतना मैम, 9 बजे break, okay, 9 बजे break, ठीक है. Next, the article of association of the private company must state. Now again class, again, which is not required. Please see the question. Not required. The article of association of the private company must state which is not required. Restriction regarding issue of prospectus, restriction regarding non-acceptance of deposit from the public, restriction regarding the number of shares, and none of the above is the right answer. Yes, tell me class. The exact answer of 37. Which one is not required in article of association of the private company? Excellent. Restriction, restriction, restriction. I think in AOA, restriction is always there, right, Surinder sir? In article which is not required, this is required, this is required, this is required. So D is the right answer. Excellent, Shubhangi ma'am. Excellent. Good. So 37D is the right answer. Next, if a company commits an act of the contravention relating to what? It can be dash. It can be dash what? So the company can commit an act. Contravention mean inconsistent. Memorandum of association, article of association, memorandum of this, or none of the above. Tell me the exact answer. I'm shifting here and there so that, wake up. So what is the exact answer class? If the company commit an act of contravention, that is inconsistent. What is the exact answer? If you are saying MOA, thing cannot be rectified. If you are saying article of association, this can be rectified. So what is the exact answer? Excellent. C is the exact answer. Good. It cannot be rectified. So C is the exact answer. Excellent, Amrinder sir. Excellent. So class, please first of all share the link, copy the link and share in the Facebook, Insta, Telegram, please. Okay. Now, see the doctrine which you have to understand. What is ultra-vires? Ultra-vires is the doctrine which means beyond the power. This is ultra-vires. I am a legal teacher, okay, but I am just teaching you AFB. So it means I have just crossed my limit. Cross my limit means beyond my teaching, I am teaching you AFB. That is called ultra-vires. So that act will be totally void. Okay. This is a very famous case that Ashbury Railway Carriage RN Company Limited. This case can be come in your case study question format. Okay. So this is, in this case class, these are the powers of the company, but the company do the finance object also. This is beyond the ultra virus. Okay, so ultra virus means beyond this one. In the company class, whatever the MOA is there, you have to, the company have to work within the MOA. If any act is done beyond MOA, so that act will be called as void, that is ultra virus. Exactly. Next, doctrine of constructive notice. What is constructive notice? X person is there. X person want to do the business with that company. Okay? So company have given the MOA and AOA to the X person so that X can easily understand what the company is. Suppose if anything is missing in this MOA, suppose the X person have not read the last 10 page of MOA, so in that case, if any act done, company will be not liable. Company will be not liable. Okay, so see that it is the duty of every person dealing with the company to inspect its document and make sure that his contract is conformity with the provision, but whether person read them or not, it is presumed that he know the contents of document. That is called constructive notice. Exactly. Okay, so you can read the statement of constructive. It means it is a presumption of the outsider that he have to know everything. And what is third doctrine? Indoor management class. The next question series will be from these three doctrines, so please understand it very carefully. What is indoor management? X person is there, company is there. Company had given MOA and AOA to the X person. If any change happen in AOA, it is a responsibility of the company to tell to the third party. If they have not tell this amendment, so it means company will be liable. If any partner does, he is liable only, or all parties are liable. If any partner does an act, every partner will be liable. Himanshu sir. So in that case class, this doctrine is basically to protect the outsider, and constructive notice is there to protect the company. Okay? Exactly. Now tell me the answer. A person is presumed to have gone through the Article of Association and Memorandum of Association available with the Office of Registrar of Office, although he might to have actually not laid his hand on these documents. It means the person have not read the document. So what is called ultra-virus, constructive notice, indoor या outdoor management? What is the exact answer? What is the exact answer? What is the exact answer class? Presumption. Presumption is called constructive notice. So B is the right answer. Excellent. Next. Which of the following save the outsider by ensuring that his contract is not inconsistent with the Memorandum of Association and Article of Association? Doctrine of ultra-virus, constructive notice, indoor management or outdoor management? Indoor is the totally opposite of this one. What is the exact answer of 40 class? What is the save outsider? Save the outsider. I have told you, save the outsider. Save the outsider. Excellent. It is doctrine of indoor management. These three doctrines are in your LRB subject. Now class, again case study question. And please see it very carefully. ABC company were allowed certain credit facility on a guarantee of D person. The D have given the guarantee. Later means बाद में the account was also secured by equitable mortgage. So it means the first thing is that guarantee is done, and the second one, equitable mortgage is done. What is equitable mortgage? Depositing of the title deed only. After the words certain reason, the bank released the equitable mortgage. When the account become NPA money was also demanded from D. Who is D? D is the guarantor. D took the plea that he stands discharged to the extent of the value of mortgage which was released by the bank. It means guarantor was saying the mortgage is discharged, so I will also be discharged. So this is the exact statement or not. First one is guarantor is not discharged as the mortgage was taken subsequent to the guarantee. Guarantor is not discharged as he is liable as long the borrower is liable. Guarantor is not discharged to the extent of value of equitable mortgage as the bank has put guarantor to loss, and guarantor is discharged in the value of security of the account has been down. This is very important question. The question is very simple. Guarantee is there, equitable mortgage is there. If the bank release the equitable mortgage, so whether guarantor will be released or not, that's it. I will give you 2-minute time. Just think this one. What is the exact answer? What is the exact answer? नरेश सर कैसे रिलीज हो जाएगा? What is the exact answer? First of all, tell me the mortgager, this mortgages comes first or the guarantor comes first? Amravati ma'am? Exactly. Class, please do not forget to like the session. Excellent, Suchi ma'am. Tell me the reason. You are saying right that the answer will be from class this one. Guarantor is not discharged. Guarantor is not discharged. Now tell me the exact reason of A and B. Exactly, Ajay sir. Excellent, class. Excellent. So class A is the right answer because first of all, the guarantee is come and then equitable. So if the equitable mortgage is come, that doesn't mean the guarantor is gone. So the exact answer is given in the A1. So A is the right answer. Excellent. Okay. In the mortgage also, you know, these types of question always come from the types of mortgage. In the types of mortgage, the mortgage which is registered, it means that should be come under the first one. Okay, exactly. Good. Next one. If there is some ultra virus transaction undertaken by the director of the company for the company, it can be ratified by the board of director, it can be ratified by the shareholder, it can be ratified by the board of directors, it cannot be ratified by board of directors and shareholder. Dev sir, you are asking ma'am, why not this one, B? As he is liable. No, exact reason is this one. If the two things, if the two concepts are there now, so you have to give reason according to the concept. Yes, class. What is the exact answer of 41? 41. Surinder Pal sir, I have already told you the exact reason. If in the question it is asked about the mortgage and this one, so you have to correlate this question with the both concept. So 41 class, ultra virus, you are absolutely right. It cannot be ratified either by board and the shareholder. Excellent. Good class. Exactly. 42. If the directors of the company undertake some ultra virus transaction on the behalf of company, which of the following is possible? The decision is taken by the board of directors. So tell me, they are personally liable to the company. They can be compelled to refund the money to the company. Action for the fraud can also be taken if there is deliberate misapplication, or all of the above is the right answer. Intra-virus means within the power. Intra-virus means within the power. That is called intra-virus. So what is the exact answer of this one? What is the exact answer of this 42nd? Excellent class. They are personally liable. They can be compelled to refund. Action can be fraud. Exactly. D is the right answer. Exactly. D is the right answer. Good. Next. Which of the following is the exception of indoor management, that is person dealing with the company can suffer loss? It means exception of indoor management means person will be liable. Sorry, person will be not liable. Where a person dealing with the company has actually knowledge of the internal irregularity. What is doctrine of indoor management? Indoor management basically protect the outsider. Exception means not protect the outsider. So you have to take mark on the exception of this one. Anup sir, ratified means verification. Ratified means you can say that is verified. Okay. So class, exception of indoor, where the situation is such that the company, the person dealing with the company could have obtained information about the internal irregularity, where an official of the company is acting unauthorized and the person dealing with the company has information about this. Yeah, all of the above. 43. 43 class, exception of indoor management. What is exception? We are not protecting the outsider. We are not protecting the outsider. You have to give me the answer. Not protecting the outsider. Excellent, Suchi ma'am. The exact answer is class D is the right answer. What I said you, every question that is, totally based on the concept. So in this one, if you know the exact meaning of indoor management, then you can easily give that answer. Okay. So every point comes under this one. Next. What is not correct regarding the words member and shareholder in the context of the company? The company having no share capital have members only and no shareholder. The member of the company having share capital are called shareholder. The member of the company and shareholder of the company are different person, and all statements are incorrect. Again class, what is not correct regarding the words member and shareholder? Monica ma'am, I cannot explain in Hindi because this is the English medium question. Sorry, English medium session is going on. This marathon is specially for the English medium student, but still you can see the questions. Okay, Monica ma'am, extremely sorry. But tomorrow Praveen sir will take in bilingual language. Tomorrow Praveen sir will take in bilingual language. So class, what is the exact answer of 44? Not correct. No share, no shareholder. This is right one. The member of company having share capital is called shareholder. Right one. So what is not correct? 44. I have already explained you two things. Are Baba, this is right na? A and B is right. 44. 44. Why you people are saying all statements are incorrect? Why? By? This is right statement. This is right statement. Now just tell me, see whether this is right or not. Simply in that question, if the no share capital, that means no shareholder right, the member having share capital is called shareholder exactly. So for this one, the right answer is C. C is the wrong statement. We have to identify not correct. This is not correct. So this is the right answer. After 5 minutes, we will take break. After 5 minutes. Okay. After 5 minutes, we will take the break. Next. According to the provision of Company Act, every person holding dash of a company and whose name is entered as a beneficial owner in the records of depository is deemed as dash of the concerned company. No, Neha ma'am, tomorrow class, same question will be not. Praveen sir will take the different question. Praveen sir will take different question. So what is the exact answer of 45-1 class? According to provision, every person holding the dash of a company whose name is entered as a beneficial owner in the records of depository is deemed as dash of the concerned company. 45. 45, the exact answer is exactly 45. It's a equity share and deemed as a member of the company. Okay, so A is the right one. 44 question, ma'am. What is the not correct na? So the first statement is, Shubhangi ma'am, correct, that if the no share capital, so we cannot no shareholder, because who is shareholder? Shareholder means who take the share. Second, the member of the company having share capital is called shareholder. This is the right statement. We have to identify the not correct, na ma'am. So the member of the companies and shareholder company are the different person. Yes. Suppose I have taken the share from the Tata company. It doesn't mean I am the member of the company. I am simply the shareholder. So shareholder and this one can be the different one. Okay. Now, 46 class. Which of the following can become member of a company? Tell me. Class, which of the following can become the member of a company? Partnership firm, insolvent person. Insolvent means nothing. Person of unsound, unsigned means pagal. And company. Which of the following can become the member of the company? Class 46. Whether partnership firm can become, insolvent person, unsound and company. If I talk about the partnership firm, so in the partnership firm, partners can separately become the member, but partnership firm cannot. Insolvent, never. Unsound, never. The exact answer is company can become this one. Exactly. So for 46 one, D is the right answer. Okay, good. If a person makes application in a fictitious name, fictitious means fake name, for acquiring and subscribing the share of a company class, so what can be happen? What can be happen? He can be allotted share, he can be allotted share at his risk, he can be punished with the imprisonment up to 5 years, and he can be punished with the imprisonment up to 5 years and within fine and both. So what is the exact answer of 47? 47. If a person make application for the fictitious means fake name, 47. Nancy ma'am, just wait, yaar. I will Show you the trick. So what is the exact answer of 47? According to the Company Act class, according to the Company Act 47, the exact answer is 47. Nutan ma'am say A, 47 class. The exact answer is exactly. If a person make this one, (47). So you all are right for the 47 one class. D is the right answer. 5 years is the imprisonment that is given here. Next. The register of member can be closed by a company by giving the notice of dash days by advertisement in some newspaper. 7 days, 10 days, 15 days, 30 days. Prior notice days, whether it is 7, 21, 15 and this one. What is the exact answer of 48? The register of member, it's the registrar of member can be closed by a company by giving the prior notice of how many days by the advertisement. Advertisement, it may be in the newspaper, etc. 48. In all question you will say 30. 30 is not the right answer. 30 is not the right answer. 48 class, the exact answer is 7 days is the right answer. 7 days notice. Not 30 days notice, 7 days notice. Okay? Exactly. If you don't know these days, just skip it because it is not possible to learn all these days. Okay? After 50 question, we will take break. A member of a company is entitled to share in distribution of asset in the case of liquidation. It is the right, whether it is statutory, proprietary, documentary and basic right. The member have a 3 right. Statutory, that is given in the law. Property right, that is basically from the property. Documentary right, that is given in MOA and AOA, and basic right. What is the exact answer? (49) class. A member of a company is entitled to share in distribution of asset in the case of liquidation of the company. Liquidation, that's related to the property. Property class, in which right the property is there. Propriety right, 49. 49, no Baba, no. 49, the exact answer is, this is their liquidation of the company. Liquidation means distribution of the asset of the company to the shareholders. So the exact answer is class B is the right answer, that is property right. Last question. A right has been conferred on a member by virtue of the MOA. It means the right class which is written in the MOA and AOA. This is called what? Statutory right, property right, documentary and basic right. After this we will take break. So what is the exact answer? And class, these questions are all important. And again I am saying, please watch my YouTube videos from 28 May to till now. You will get all the questions of the topic very well. 28 May to till now, and the timing is 7:30 PM topics and 9 PM topics. So what is the exact answer? Written in this one, so that's why documentary is the right answer. Exactly. Documentary is the right answer. Okay, class? So, we will take a break. We will take a break of 5 minutes. After 5 minutes, I will come. Okay? 5-minute break. 5-minute break. It's a 9:05. We will meet at 9:10. Okay, class? We will meet at 9:10. Bhanu sir, class up to 11 p.m. Okay? Hello everyone. Yeah, hello, I come. आ गई. I need this, I need this. I need this one. Yeah. So class, one word to remember the types of mortgage. Okay. Shall we start the class? Shall we start? Okay. So class, one word to remember the types of mortgage, and these types of mortgage is very, very much important. Simple mortgage, first of all, what is mortgage? Mortgage in which we just generally give the immovable property as a security, that is called mortgage. Okay. In simple mortgage, no delivery of the possession, that is a key word to remember the simple mortgage. Okay. Mortgage by conditional sale, conditions are there. In the conditional sale, mortgage deed will be automatically converted into the sale deed. Usufructuary mortgage, mortgagee can use the property as a rent and profit. English mortgage, the transfer of mortgage property absolutely. Okay, transfer the this one property absolutely, and certain date is defined when the mortgagor have to give the money. Fixed rate mortgage, interest is fixed. Anomalous mortgage, it is a combination of two or more types of mortgage. Anomalous means which is not simple, which is not conditional, which is not all these things. Reverse mortgage, that is on the installment. The lender will give the money on the installment basis, that is called in this one reverse mortgage. And what is equitable mortgage? Equitable mortgage is also known as mortgage by deposit of title deed. There is no need of registration in equitable mortgage. Okay, there is no need of. Anup Tiwari, sir, in usufructuary also the possession is given to the mortgagee. So this is called class the types of mortgage in a one word, so you can easily remember that mortgage. Now next one. Again class, case study question. I hope so you people are liking the way 10 question, concept, case study question, that's it. Sambhu Dayal started the self-service system in his shop. Srimati Prakash entered the shop. She took a basket, and after taking the articles of her choice into the basket, she reached the cashier for the payment. The cashier refuses to accept the price. Can Sambhu Dayal be compelled to sell the said article to Srimati Prakash? Say yes or no. XP Gamer sir, in simple mortgage, there is a no transfer of possession and the mortgagee can sell the property with the intervention of the court. Okay, Gamer sir. So class, you have to tell me whether the cashier, refused to accept the price. So can Shambhu Dayal be compelled to sell the said article? Say yes or no only. Say yes or no only. So you people are absolutely right. The answer is no is the exact answer. Exactly. Okay. This is basically invitation to offer. Okay. It's a invitation to offer. Exactly. Next. 51. The member of a company can inspect. I have given you the hint. Inspect the register of member by the virtue of the right, whether this inspection is written in statutory right, property right, documentary and the basic right. 51 class. Kumar Gaurav sir, 2 hour more. 2 hour more, yaar. Just do the questions, na. Questions are very important. What is the exact answer? In which rights class? In which right you can inspect. You can inspect. Inspect. Exactly. A is the right answer. In statutory right, we can inspect. Excellent class. Good. Next one. A company wants to invite the deposit from the public. For this purpose, he have to issue public notice, circular, prospectus या instruction. 52. Nisha ma'am, there is a statutory right, there is a documentary right. Statutory right, that is simply the law is made and in that law the rights are given. Documentary means the rights is given in MOA and Article of Association. I think you all have covered in the paid batch. So class, what is the exact answer of 52? Absolutely right, class. In the prospectus which define the outlines, that is the right answer. Good. If it come to the notice of partner of the firm, now class, partnership question come. This is very, very important, Partnership Act. If it comes to the notice of partner of the firm that one of the partner is carrying on a business that is competing business with the firm. So class, what is the exact answer? The said partner has to close that business. The said partner has to merge this business with the business of the firm. If separate business is continued and there are profits from the said business, the profit have to be shared with the other partners. Yes, said partner has to undertake to close the business in the fixed period of time. Yes, Kumar Gaurav sir. Yes, class, if it comes to the notice of the partner that one partner is carrying on a business that is competing business with the firm. So just learn the concept of partnership and give me the answer. 53. What is the exact answer of 53, class? That is very simple. The answer is written in the question. The answer is written in the question, class. The answer is totally written in the class. 53. Come to the notice, class. If one partner, I will just come to this side. If one partner is doing business, every partner is liable. If one partner is profit will be distributed among the all. So what is the exact answer? Anand Kumar sir, you are saying D, Baba. Why? C is the right answer. If the separate business is continued and there are profit from the said business, the profit have to be shared with the other partners. 53. C is the right answer. If any wrongful act done by the partner, it's okay, the other partners didn't know, but still all partners will be liable. This is a concept of your Partnership Act. So 53 exactly, Malti ma'am, Poonam ma'am, C is the right answer. Excellent. Okay, now, next question. In the case of the partnership firm, all the partners play a dual role. Owner and servant, principal and agent, shareholder and debtor, and seller and buyer. This is very good question. Ganesh sir, if any one partner loss, the loss will be bear by all the person. Kavita ma'am, if any one partner, if suppose 5 partners are there, A, B, C, D, E. The concept of the partnership is that if any, suppose A partner is doing business and these person don't know that the A person is doing business, still all the partners will be liable because the concept of the partnership talk about this one. So class, first of all, tell me what is the relationship between the partners? The 3 options are there. Exactly, Anand sir. Okay. Good, Rohini ma'am. So the dual nature of partner is that partners, this is principal and agent. We have learned the concept of this one in the Indian Contract Act. So same will be applied to this one. Exactly. Okay. So principal and agent will be the right answer. Next. When a partner acts for the business of the firm on the behalf of all the partner, it is called express authority of partner, authority of a partner, implied authority, or any of the above. Express means written and oral. Implied means by act and conduct. What is the exact answer? This is very important. This is very important question 55. At least do the century at 10 a.m. After that we will do more questions. So Dheeraj sir, what is the exact answer? Vipin sir, Suchitra ma'am, kaise hain aap log? How are you? Rohini ma'am, any of the above? What are you saying? Any of the above is the right answer? Huh? 55 question, Baba. The exact answer is, this is the implied. Implied means by the way of act. If one partner is doing business, so by way of act, we can assume that all the partners have done the work. So that's why 55C is the right answer. Okay? Good. Next. Which of the following action cannot be taken by the partner by using his implied authority? Means partner cannot do that thing. What? To appoint another person as the agent of business, to sell the immovable property belonging to firm, do fraud, and none of the above. 56. This is very simple question. 56. Yes, class, 56 is very. What the other partner cannot do? He can appoint another partner. If the consent is not there, never. He can sell the immovable property, never. He can do fraud, never. So what is the answer? D is the right answer, 56. 50. Are Baba, why you people are saying C? D is the right answer now. The partner can do fraud, hai? Rahul sir, you are saying C1. The partner can do fraud. Na, Baba, na. So the exact answer is D will be the right answer. None of the statement can be the right one. None of the statement can be the right one. This is the right answer. 56. D is the right answer. Okay. Next. In order to save a firm from loss in an emergency, one of the partner of the firm took an action which was not in his implied authority. So tell me, class. Yeah, exactly. It was all of the above. It was written none of the. Okay. Excellent. In that question 56, it is all of the above. Okay. Now, so class, just this question, in order to save the firm from loss, one of the partner of the firm took an action which was not in implied authority. Only he is liable for any loss. Other partners are liable for that action. Other partners are not liable for that action, and none of the above is the right answer. Tell me the exact answer. Exactly. What is the right answer of 57, class? If a loss is done by one partner, what is the exact answer? Loss is done by one partner, whether all partner is liable or not. 57, B is the exact answer. You know, class, the loss word is not written in the definition of the partnership. So it doesn't mean that in loss, the partners will be not liable. In the loss also, every partner is liable. Excellent. Next question. If a partner transfer his interest in a firm to the another person, which of the following is not correct? If a partner transfer his interest in a firm to the another person, the transferee means the outsider, is entitled to all the rights of transferor partner. The transferee cannot interfere in the business of firm. The transferee has to accept the account of the firm agreed by the partner. And the last one is, if the firm is dissolved, the transferee is entitled to have share in the asset of the firm. 58 question. 58 question. What is the exact answer of 58? If a partner transfer his interest in a firm to the another person, that is outsider, which one is not correct? Which is not? Sheetal ma'am, what I have told you, from 28 May you have to see the YT session in which we have already covered module A, B and C. Okay ma'am? What is the exact answer of 58 class? 58. The transferee is entitled to all the rights of transferor partner. The transferee cannot interfere in the business of the firm. The transferee has to accept the account of the firm, and if the firm is dissolved, transferee is entitled to have share in the asset, which is not correct. Which is not correct. So Parul ma'am, 58 one, not correct. A is the right answer. A is not correct. A is the right answer. Transferee is entitled to all rights of the transferor. This is not the right answer. Because if we have transferred the interest, that doesn't mean everything is transferred. No. So this is the wrong answer. So that's why this is right one. A is the right answer. Okay. Now, next one. These questions are very important. The student who are saying, ma'am, where is the question for module A, B, C? So class, in the first minute of this session, I have told you from 28 May, you have to go to the playlist of Officers Adda YouTube channel and you have to see the session of 7:30 PM and 9 PM in which we have done module A, B and C. Yes, class. A minor cannot, oh my God, minor again come class, minor. A minor cannot become partner because he is, as per Act, not competent to the Partnership Indian Contract, not competent to contract under this Act, not competent to ratify the Partnership Act, and not competent to contract Section 22. 59 question. 59 question class, that is very important. Partners cannot enter in the contract under which Act it is written. It is written under the B is the right answer. Not competent to contract because of the Indian contract it is written. B is the right answer. Good. Sam sir. It's Abulesh sir. Excellent. Good name, Abulesh sir. B is the right answer. Okay. Next. If a minor becomes major while he was admitted for the benefit, he is deemed to be partner of the firm automatically, deemed to be not partner of the firm, to take a decision to become partner or not within 6 months, and any of the above. 60 question. If the minor is there, he is a partner, so he have a 6 month, he have to declare. Suppose if the minor become major, actually the minor is not the, minor cannot become the partner, but if he become the partner, so in that case, he have a 6 month time to give the public notice. Public notice means whether in the newspaper, etc., that whether he want to become partner or not partner. So what is the exact answer? Excellent. C is the right answer, to take decision to be partner or not within 6 months. This is the right answer, and that is given under Section 30 of the Indian Partnership Act. Exactly. Next. Again, a new concept. Right to Information Act, that is very important. We can easily demand the information from the public authority, but not from the private authority. Okay. So, in that case, we can demand the information from the public information officer. The request should be in writing. We should not have required to give reason that why I am asking question to the public authority. Next, ₹10 rupees is the form of RTI I have to fill up and send to the particular address. Information should be come within 30 days. And if the question is about life and liberty, suppose if someone detained me, it means my life and liberty is detained. So in that case, within 48 hours, reply should be come. And RTI is a legal right. And in 2025, this RTI Act is of 2025, it is a quasi-judicial authority. What is quasi-judicial? Quasi means the half. Mohit sir. Exactly, Indrajit Mitra sir. If he is not taking decision within 6 months, he will be automatically become the partner. Mohit sir implied means, Mohit sir, suppose if you go to the Domino's, you will not ask for the tea. In Domino's, you will ask for the pizza. So you will automatically go to Domino's, you will order, pizza will come, you will eat, you will go. So implied means by the act, you are doing contract. Express means, suppose this is the express. I'm explaining you, I'm teaching you, that is express contract. And implied means, by the way of act, you can say that, oh, the contract has done. Quasi-judicial means, quasi means half. So whatever the matter that's come under this one, the authority will be called as a quasi. Quasi means they do not have to follow the rules and regulations of the court. They can make their own rules under RTI. Okay, good. Next, again class, question, case study. X is a minor who was studying in MCom in a college. Okay, X is a minor. On 1st July 2005, he took a loan of 10,000 from B for payment of his college, for the payment of his college fees, and purchased the books and agreed to repay by the 31st December 2005. X possesses the asset worth of rupees 2 lakh. On due date, X failed to pay back the loan to B. B now wants to recover the loan from X out of his X asset. So, referring to the provision of Indian contract, decide whether B would be succeed or not. A very good question. Yes, class, tell me the exact answer of this one. Abulesh sir, I have given you this one. Kapil sir, give me the reason. Don't say me yes or no. Dheeraj sir, give me the reason. Give me the reason. Amit sir, minor cannot take loan, but still minor can do everything. Minor can do everything. Just tell me the reason of this one. Reason. Will B succeed or not? No. Minor cannot take loan. Are Baba, in that case, minor have already taken the loan, na? Minor have already taken the loan. Exactly, class. Please see this question. This is very important question. First of all, the answer will be yes. B will succeed. Just see, class. That is the example of quasi-contract. That is example of quasi-contract. What is quasi-contract? Initially, you can, okay, don't take this quasi-contract, but in this one class, the B person cannot demand personally the loan from the minor. See, the B person cannot demand loan from the minor because you know that if any agreement is done by minor, that is void ab initio. But B person can demand from the X asset, na? And if you know this example, in the quasi-contract class, the first type of quasi-contract, that is supply of necessaries. Supply of necessary means the B have in that case supply the loan and the minor have, purchased the book. So book means that is necessary for the minor. So that's why the B have done the quasi-contract. Exactly, Neeta ma'am. Okay, so class, for that one, B cannot demand money from the minor, but he can demand money from the X asset. So that's why he will succeed. And what is quasi-contract? Quasi-contract means it's a half contract. In generally contract, we do the offer, acceptance, etc. But in quasi-contract, simply contract is done and then formalities are going on. That is called quasi-contract. Okay, so this is the right reason. So these questions, see class, if I just tell you these types of question, many people is very afraid, oh my God, this much question. So just tell me, these case study question is totally based on the concept. If you know the concept, you can easily see this. If you know the concept, you can do any question class. You can do any question. So that's why it's a request to all of you to clear your concept. I think many students are from this one, page class. So their concepts are they are clear. But those candidates who are new in this session, they have not attended the paid batches. So you can easily purchase because one day is left. And one day, if you purchase the power pack in the English medium of LRB, I think 6 to 7 hour class is there. You can easily cover your concept. You can easily cover your concept if you want to understand in the English medium. Because I have done the power pack, means 6 to 7 hour class of LRB in which all the concept I have cleared in the power pack of English medium. So if you want, one day is there. You can. Okay, next. If a minor becomes major while he was admitted for benefit and he does not take any decision to be or not to be partner, it means he is keep silent. What will be the answer? He is deemed to have become partner if he remains silent for 6 months. He is deemed to have no association with the firm. He cannot become partner. He is not liable for the firm. अरे श्रीजन सर, मैम आते हैं अगली बार. Why? You can easily, भाई, crack your exam. Don't say like that. Don't say like कि हम आते हैं अगली बार. Don't say. So the exact answer of 61 is class. A is the right answer. That is, he is deemed to become partner if he remains silent for the 6 months. Excellent. Next. If a minor become major, choose to be the partner his liability. See class, this question is totally based on section 30. The section 30 concept is clear. You can do that question. Minor become major, choose to be the partner his liability. Begins from the date when he decide to be partner. Begins from the date when he become major. Begins from the date when he was admitted for the benefit as minor, and begin from the expiry of 6 months after become majoring. When the partner will be liable? This is very important question. When partner become liable? This is very important. Rohini ma'am, in CIB, I think there is no legal subject in the previous, old syllabus. It may be in the new session, there may be the law subject in CIB also. So what is the exact answer of 62 class? Exactly, class. It will begin from the benefit. This is very, 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 very important question. This is right answer. You people are discussing in this one group also, na? So class C is the right answer. Okay, C is the right answer. The day he admitted for the benefit, on that day, the minor will be liable. Okay? Next. If a partner is declared to be insolvent, now class partner, there is no minor. The partner is declared insolvent. Which of the following statement is incorrect? If the partner is insolvent, which of the following is incorrect? He ceases to be partner of the firm from the date order of the adjudication. Insolvent, in the insolvent case, it means diwaliya hona. When the court will declare, then only you will call as the insolvent. The firm may dissolve or may not dissolve, that situation. If the firm is not dissolved pursuant to the contract, the estate of the partner declared insolvent is not liable, and the firm shall be liable for any act of the insolvent done by him after the date on which order of adjudication was made. 63 question. If a partner, suppose 5 partners are there, one partner become this. One partner become class. One partner become insolvent. So what will be the situation under the 4 points? Yes, 63 question class. Incorrect class, in question shall be incorrect. This incorrect word will be, incorrect. In this question, he ceases to be partner from the date he adjudication. This is the right answer. The firm may dissolve or may not dissolve. That's depend upon the class contract. If the contract it is written that one partner is insolvent, the partnership become insolvent, then it will be done. If it is written that if one partner is insolvent and the partnership cannot be dissolved, so it will be done according to this one. C is if the firm is not dissolved pursuant to the contract, the estate of the partner declared insolvent is not liable for any act of the firm. Exactly. Person insolvent is different thing. Property insolvent is different thing, or you can say the company insolvent is different thing. So which is the incorrect class? So D is the incorrect statement. D is the right answer. Vijay Mallya is insolvent, but Vijay Mallya company is insolvent, but Vijay Mallya is not insolvent. Okay, exactly. Next. If a partner of a firm can retire from the partnership firm, retirement means tata bye-bye of the partner. What will happen? With the consent of other partners only, as per express agreement between the partners only, by giving notice to the other partner if the firm is at, I think option is missing, or any of the manner. 64 question. Yes. What is the exact answer? I think if the partner is retired, so notice he have to given this. D is the right answer. Excellent. D is the class right answer. Okay. Next. In which of the following circumstance the firm can be dissolved by the court? Firm can be, we have done now types of dissolution of partnership firm. Section 44 by dissolution by the court. So which is not correct? A partner has become unsound mind. A partner is guilty of conduct that is likely to affect the carrying on the business. A partner has become permanently incapable of performing the duty as partner, and in all of the above circumstances, the court can automatically order to dissolve the firm. 65 question. Partner is unsound. partner is guilty of conduct, partner has become permanently incapable, which is not correct. This is so simple, class, so simple. (65) absolutely right. D is the right answer. That is not correct. Okay. Next. In the firm class, several types of business and one of the such business has become unlawful due to the certain event. So, see class, the question is very simple. The firm have several types of business. Several means there are so much business. Several means there are so much business. And one of such business has become unlawful due to the certain event. So much business, one business is unlawful. The firm has to close the whole business. The firm has to start the whole business afresh. The firm can continue with the business. It was not major portion. The firm can continue with other business by closing the unlawful business. 66 question. 66 question class, that is very simple. 66. And class, please do not forget to like the sessions and please copy the link and share it in your WhatsApp group, Telegram, etc. Excellent class. D is the right answer because there are several business in which one business is the unlawful. Exactly. Okay, good. I just want to tell you one thing, that many candidates pass because of seeing the marathon. So, sir and ma'am, don't lose the hope. If you watch the marathon sincerely of tomorrow's session and today's session, you can definitely crack your exam. It is guarantee, 100% guarantee I am saying you. Many candidates take, paid batch. Many candidates see the recorded videos. Many candidates see the YT session. So, there are so much ways in which you can crack your exam. Okay? Good. In which of the following that is not correct? A firm is dissolved if all except one partner is declared insolvent. A firm is dissolved if the business has become unlawful due to some event. If the firm is dissolved if the term has expired, and the firm is necessarily dissolved if one of the partner dies. 67 question class. What is not correct? Not correct. Ma'am, ये question form से किस? Ma'am, ये Parul ma'am, this question is basically from the Partnership Act, ma'am. The death day, sir, you can easily get 57 marks. Sheetal ma'am, at the last, I will show you where you get all the YT sessions. Sheetal ma'am, don't worry, just chill. So, class, for the 67 one, the exact answer is D is the not correct one. If the firm is necessarily dissolved, if the one partner die, that is not the right one. If there is a contract between the partner, that one partner die, the firm will continue, so it will be continue. So, that's why D is the not correct. Next. Which of the following regarding the company and firm is not correct? It is about class. This is about the company and firm, both one. Okay. A company has to be registered necessarily. A firm can be registered at the option of the firm. A firm may not get itself registered, and the firm and company have to be get registered with the ROC, which is not correct, class, not correct. Not correct. Vimal sir, at the last of the session, I will tell you where is the power pack session of the English medium. I am telling you class, 6 to, no, it's a 1, 2, 3, 6, 6, 7, 8, 9. 9 hour class is there in which you can, and you have a 1 day, If you revise the 9 hour, you can easily clear your concept. In the last, I will tell you where you can purchase this paid batch of English medium. What is the exact answer? Not correct. Not correct. Exactly, this is not the correct, because partnership, it is not compulsory to register, but for the company, it have to be registered with the ROC. D is the right answer. 69. As per section 69, 69 talk about in the partnership firm that non-registration of the partnership firm, that is section 69. If a firm is not registered, which is not correct, and class, in the question please see this one, not correct. No, Nancy ma'am, 9 hour class of all module of the important contents I have taken. So if you want to read and understand all the concept of 4 module, then I will show you the particular batch in which you can easily revise the concept, because question you will cover in the YT session and the concept by this paid batch. So class, what is the exact answer of 69? A partner cannot file suit against partnership firm. It is all about, class, if the partnership is not registered. This is right. This is right. This is right. A partner cannot file suit against for the dissolution of firm. Exactly, Sam sir. 69 question, class. What is the exact answer? D is the right answer. At least you can file for the dissolution of the firm. You can file for the dissolution of firm, class. A partner can file a suit for the dissolution of firm. So D is the right answer. Now 70 question. Which of the following is not correct regarding the company, class? Not correct regarding the company. It requires registration under Company Act, registration with Company Law Board. Again, class, not correct. Company is artificial legal person. Company is dissolved by process of law. You know, class, this question just tick mark which statement is right. Company dissolved by process of law? Yes. Company is artificial legal person? Yes. Yes, yes. Company registered with this one? No. Company registered with this one? Yes. So which is not correct? So 70, the right answer is B is the right answer. So just try to solve this question, okay? In that way. Now, that is very important. Now see the trick of, class. The terms is of FEMA. FEMA, that is Foreign Exchange Management Act. It's a Foreign Exchange Management Act. Authorized person, the person which is appointed by the RBI, that is called authorized person. Okay? What is current account transaction? In Hindi, rupees वापस नहीं आएगा. Rupees वापस नहीं आएगा. Example, if you have spent money for the education. And what is capital account transaction? Rupees वापस मिल जाएगा. Example, loan. And what is repatriate to India? Repatriate means dollar लेके जाओ, बचा हुआ वापस दो. That is called repatriate. It means, suppose if I go to US, so for US I have to take a dollar. So whatever dollar that I just return back to India, that is called repatriate to India. Exactly, Satish sir, earlier it was FERA. So this is, class, the exact answer of this one, FEMA. Okay, so hope so you understand the terms which is written here. Penalties. Very important of FEMA. See, class, if a person contravenes, what is contravenes? Inconsistent. the provision of FEMA or any rule, direction, regulation, order, notification issued under FEMA, he shall be liable to pay the penalty thrice the money if it is quantifiable, that is calculated, and up to 2 lakh rupees if it is not quantifiable. When such contravention continue, he is liable to pay 5,000 rupees for the every day during the contravention. This is very, very important penalty. This is very important session class. This is very, very much important. Please note down at least these things. Okay, so I think that is clear to all of you. Okay, now a company have a separate perpetual, a company has a perpetual succession, which means which of the following is not correct statement? It does not get dissolved due to the death of the member. It continue as a separate legal entity. The insolvency of member affect the existence of company, and the member can come and go but the company continue, which is the not the correct statement class. 71 class, what is the exact answer? 71. Not correct. It does not get dissolved due to the death of the member. This is right statement. It continue as a separate legal entity. This is right statement. The insolvency of the member affect the existence of company. This is wrong. The member can go and this company continue. This is right. So the exact answer is C. Excellent. C is the right answer. Excellent class. So class, just wake up. Okay. Next question. A company can be held liable only when the documents bear the signature. The company can be held liable only when the document bears signature. You know that signature means the common seal of the this one. Triputi sir, perpetual means the long lasting. That is called perpetual. Just like your pardada property transferred to dada, dada to papa, papa to beta, that is perpetual property. So what is the exact call? To ensure this, what is the specifically taken care by the banks of extra precaution? The bank gets signature of authorized person. The bank obtains resolution from the board of director. The bank get common seal of the company affixed with the all important document and all of the above. 72 class. A company can be held liable only when the documents bear its signature. To ensure this, what is the specifically taken care by the bank and extra precaution? And one thing I just want to show you, common seal is now optional for the company from 2000, this one. So what is the exact answer of 72? For 72 class, exactly, D is the right answer. Why? Because class, now the common seal from 2000 is not compulsory. So that's why D is the right answer. Good. A company is class different from the partnership firm in respect which of the following? Choose the incorrect statement class. We have to choose the incorrect statement. Member of a company are not agent of the company, but partners are the agent for each other. This is, I think, 73. That is right. A company has perpetual, but firm can be dissolved and get dissolved. This is also right. The liability of the firm and shareholder in company is similar. No. The liability of the partner is unlimited and this is limited. That's depend upon the types of company. The death of the shareholder does not bring the company to an end, but death of the partner can bring company to the end. That is right. So the exact answer is 73. C is the right answer. Exactly. Okay. Next, which of the following statement is false? Director of the company represent the shareholder of the company. The shareholder of the company are the joint owner of the company. Company can enter into contract its own name. If all the member of company die, the company has to be wound up. Which of the following is false, class? 74. And please, class, do it very sincerely. These questions are very, very much important. What is exact answer of 74? Exact answer of 74. Now, please do it very fast because we have so much less time. We have so much less time. So, for the 71, which is the false, so D is the this one. As we know that company have a separate legal existence, so that's why if the member die, that doesn't mean the company will also die. Okay, so D is the right answer. If a company is created under some special act of the parliament, it is known as government company, public sector, public limited company, or statutory company. What is the exact answer? What is the exact answer of this one? By the parliament. Parliament, exactly, that is called statutory company. D is the right answer. It is called statutory company. Okay, next. Where liability of the member of company is limited by the memorandum of association to such amount of the member undertake to contribute to the asset of the company as liquidation of the company. Suppose if the simply company by unlimited, limited by liability, guarantee and maximum liability. In the paid batch, I have already shown you the types of this one company. So you have to focus on that concept and tick mark the answer. 76 class. And class, do not stop. Do as much as question. By the God grace, you may success in the LRB exam with a good marks. So, what is the exact answer of 76 class? 76. It's a member of company is limited by the memorandum to such amount of the member to contribute this one company. It is called class 76. 76, excellent. 76, the B is the right answer. The answer is given in your question. 76, B is the right answer. Good. Next. If the company is limited by guarantee, what is limited by guarantee? Suppose if I given the guarantee that only 50 lakh, if the member is saying only for the 50 lakh, I will be liable. So that is called limited by guarantee, that the member have given guarantee of only 50 lakh. So it may or may not have share capital. It must have the article of association. The members are required to pay only the fixed amount, and all of this statement is correct. 77. 77 class, what is the exact answer? 77. Limited by guarantee. This is very easy. Limited by guarantee. C is the right answer, that members are required to pay only the fixed amount, that the example I have given you. Okay? Exactly. Next one. What is a public company, which is the most appropriate definition under the Companies Act? Whose shares are listed on the stock exchange, who can invite public to subscribe its share, which is not the private company, and all of the above. Which is the right answer? And class, please wake up, okay? You can easily see the question by just, in your bed also. But please solve all the question. This is all important one. So 78.1, what is the exact answer? D is the right answer, definition according to this definition. 79. Which of the following is class correct about the sub-agent? What is sub-agent? That is so simple. This is principal, this is agent, and this is sub-agent. Sub-agent, whatever the mistake done by sub-agent, agent will be responsible, and done any wrongful act done by agent, principal will be liable. So what is the exact answer of 79 class? 79, it can be appointed by agent. Sub-agent is liable to the principal even appointed without consent of principal. If appointed with the permission of principal, the sub-agent is liable to the agent but not to the principal, and none of the above. That's why I'm just doing question in the fast manner. Just tell me the answer, class. I have already given you the hint. 79 question. 79 class, I have given you the hint. The exact answer is C is the right answer. If the appointed by permission of this one, still for sub-agent, agent will be liable. For the wrongful of agent, principal will be liable. 80 question. In which of the following circumstance the agency is not terminated, class? Agency is not terminated when the principal invokes the agency, when agent is declared insolvent, when the business of agency is completed, and when the agent give up, renounce the business. Renounce means sab moh maya hai. Renounce means sab moh maya hai. Not terminated class, not end. What is the exact answer? Not end. And please do this question as soon as possible, because tomorrow some more question will taken by the Praveen sir in the bilingual language. So for the 81 class, see, 81 class, B is the right answer. If the agent is declared insolvent, that's not terminate the agency. Okay, B is the right answer. Now, this is the class chart of the SURFACI Act. This is very important. Borrower had taken money from bank. So suppose bank have given money to this one, and borrower has taken security. Borrower has given security to this person. Now suppose borrower is not able to pay the money. This is, class SURFACI Act. This is a process of your SURFACI Act, which is very important. SURFACI Act, in which there is no intervention of the court. Exactly, Divya ma'am, this video will be available in the YouTube. So class, what the bank will do? Now the bank will ask the ARC company, the bank will give this security receipt to the ARC company, and ARC company now give cash to this bank. Now ARC company will find the qualified buyer. So this is the qualified buyer. Fifth, qualified buyer will take the security, and this will give cash to this one. So this is the process of SURFACI Act. This is the process of class SURFACI Act. Okay, next. The agent is required only, class, at least just do the 100 question. Okay, just do the 100 question. After that I will show you the remaining YT sessions, and the third one, paid batch of English medium, in which you can easily learn all the concept within 9 to 10 hours. So what is the class? Agent is required to conduct the business as per direction given by principal. If there is no direction as per custom, if agent act otherwise, he is liable and benefit from the agent, benefit from the gain, and all of the above is the correct one. 81. No need, sir. So what is the exact answer of 81 class? Agent is required to conduct the business. What is the exact answer? 81. 81 class, the exact answer is excellent. 81. D is the right answer. Good. D is the right answer. X directed Y to sell his estate. Y purchased it in the name of Z, which is discovered by X. Later on, X to reject the transaction. X may repudiate. Repudiate means cancel. X may repudiate the transaction if he could prove that Y has acted dishonestly and X had accepted the transaction. 82 question class. Y purchase in the name of Z, it means there is some dishonest intention here. There is some dishonest thing in this question. X directed Y to sell his estate. Estate means property. Y purchase in the name of Z. In the name of Z means something wrong is there. Something wrong is there. So for 82 one class, what is the exact answer? 82? Baba, X may repudiate the contract transaction if it could prove that X has acted the dishonestly. Okay? Exactly. Next. Under the sales of good, the term goods include what? Now class, sales of good question. Sales of good. So under the goods class, the sales of good means stock and share, growing crops, things attached to the earth, yeah, any of the above. 83 question. Stock and share, growing crops, things attached to earth, but which is agreed to be severed. Severed means alag ho gaya. Severed means class alag hona. So what is the exact answer? Excellent. D is the exact answer. Next. Under the Sales of Good Act, the definition of which of the following is not correct? The price means consideration for the sale of goods. Delivery means, this is the definition of price, this is the definition of delivery, this is future goods and this is specific goods. So you have to find which of the following is not correct. Which of the following is class not correct? 84 question. This is very simple question class, not correct. Not correct, not correct, Baba. Specific good, that is right one, identified. Future goods to be manufactured, this is right one. Delivery means transfer of possession from one person to another, voluntary or otherwise. This is wrong, so B is the right answer. 84, ma'am, B is the right answer. This is the wrong statement. This is the wrong statement. Next, as per sales of good, when transaction becomes sale class, when transaction becomes sale, only when the goods are delivered, buyer by the seller, only when the property in goods is transferred from seller to buyer, when the property in goods is transferred from seller to buyer with and without partition. Yeah, all of the above is the right answer. 85th. When the transaction becomes sale, when the transaction becomes sale class. 85. Transaction becomes sale class. 85 one. Aha, you have to wake up, Baba, wake up. Ma'am को नींद नहीं आ रहा, आपको कैसे नींद आ रहा है? This is all for you class. These all questions are only for you people. And only one day is left. After 1 day, when you clear your LRB and clear your JAIIB, the increment will be given to you, not to me. So please wake up. So what is the exact answer of 85 class for 85? Sale, it is C is the right answer. Na, D na. It is only you cannot say that this is the right one. This is not the right one. This is class right. Only is not the right statement. So that's why C is the right answer. 85-1 class, C is the right answer, because we cannot say that only this can be happen. No. Okay? C is the right one. Which of the following is not essential element for the contract of sale class? Not essential. There is a bilateral contract. Bilateral contract means both parties doing contract. The consideration can be money and exchange of goods. Consideration means something for something, price, money. The property is a movable property and not immovable. And the contract of sale become oral and written. You have to tell me not the essential points class of contract of sale. Not the essential point. Srijan sir, bhai. You can easily understand that how this JAIIB CAIIB exam is very essential to all of you. The money, everything, you know, money. What is the exact answer of 86 class? 86. Not correct. So class B is not the correct one. Na? The consideration can be only money. It is not exchange of goods class. So 86-1, B is not the essential point. Class B is not the essential point. Na? The consideration should be money only. Why you people say exchange of goods? In the sale we exchange the goods. Na? 86C is the right answer. Yahan se wahan. 87. When the transfer of property in the goods is to be take place at the future time or subject to the certain condition to be fulfilled after the contract. It's a very simple question. 87. In the Sales of Good Act, 2 is there. Only 2 this one. Sale is there. Agreement to sale is there. Sale is present and this is future. So what is the exact answer? What is the exact answer, class? The answer is here. The answer is here. The exact answer is C is the right answer. Next. When the party in a contract agreed that the sales of goods shall be regarded as a final sale only on the fulfillment of the certain conditions, either before and after the conclusion of the contract. So what it is called? Absolute, conditional, agreement to sale and sale agreement. 88 class. Some conditions are there. Conditions have to fulfill. What is called? What types of sale is called? 87. One. Baba, certain condition have to be fulfilled after sale, before sale. So the exact answer is conditional sale is the right answer. 89. Which of the following class statement is correct? Which of the following statement is class correct? The risk in good in a sale is with the seller. The parties have performed their part in an agreement to sale. If the risk is yet to pass on the buyer, it is agreement to sale, or where parties are yet to perform, it is sale. Which of the following is class correct? 89 class. The definition of sale, agreement to sale, and this is sale. What is the exact definition? 89 class, come on, wake up. What is the exact answer of 89? 89 one. Exactly, this is the right statement. This C is the right statement. Excellent. Excellent class. Next. As per the sales of goods, the goods do not include shared stock, grass, actionable claim. What is the exact answer? What is the exact answer? Not includes in the goods. 90 question. The 90 question, actionable claim not come under this one. D is the right answer. Excellent class. Next. Loan which is not eligible under SURFACE. Please read the question. I'm just coming within 1 minute only. Yes, class, loan which is not applicable. This is a SURFACE Act, okay? Actionable means in which we can take action, sir. Which are not eligible under SURFACE, the loan which is secured by lien pledge, this SURFACE will not apply. What is SURFACE Act? SURFACE Act means without intervention of the court. Without intervention of the court, simply, okay, without intervention of the court, how we can get money from the borrower, that is called SURFACE. So, but this point SURFACE will not apply. Vessel, aircraft, agriculture land, hire, purchase, lease, unpaid sailor, property not liable for attachment of sale, loan up to 1 lakh, this is important, where due amount is less than 20%, limitation has been expired and security is not charged to the bank by borrower. Under this case, SURFACE Act will not apply. Under this Act, SURFACE Act will be not apply. Okay? Now, under the Sales of Good Act, goods that are identified and agreed upon at the time when the contract of sale is made, this is called what? Identified class. Specific goods, future goods, movable and immovable goods. What is the exact answer? What is the exact answer for this one? चाय है? Yes, class, what is the exact answer? 91. 91, the exact answer is specific is the right answer because it is identified. Excellent. Under the Sales of Good Act, that stipulation is called collateral to the main purpose. So, I have already cleared the concept of condition and warranty. So, what is the exact answer? Condition, warranty, guarantee and implied condition. Main 92. Collateral to the main purpose of the contract 92. 92. Main purpose of the contract 92, it's a what is the exact answer of 92? 92. Collateral means class collateral, that is warranty is the right answer. Okay. 93. Under sales of good, there is an implied condition on the part of seller that he has to write off dash the goods. Use, retain, sell and resell. Retain means hold. What is the exact answer? Come on class. मेहनत करिए, सफलता आप ही लोगों को मिलेगा. What is the exact answer? 93. There is implied condition on the part of seller that he has a right to. Seller का बताया है. Seller right to 93. ना. Under sales, there is an implied condition on the part of seller that he has a right to dash the goods. Baba, लेकिन इसमें retain. Why it is retain? Because it is not written that the buyer has not, this one paid the money. So for the 93 class, C is the right answer. C is the right answer. 93, C is the right answer. Okay? Now, this is very important concept class, caveat emptor. Chini ma'am, it's the less, okay? 50% or 25,000, less is the right answer. So class, the caveat emptor is a legal maxim. It means let the buyer be aware. So what is the exact answer? The seller should recover the price before delivery. Buyer should cautious while purchasing the goods. Seller should deliver the goods only after receipt of full price. Buyer should make the payment only after receipt of delivery as per the quality and quantity. What is the exact answer of 94? 94, buyer should be, B is the right answer. Gaurav sir, constructive notice means, suppose if any third party is coming to the company, he want to do business. So under this, if the company is giving MOA and AOA to read, so whether third party Gaurav sir read or not, that doesn't matter. It will be presumed that he have read all thing. That is called constructive notice. Next, if the sale of good is by sample and there is an implied condition under Sale of Goods Act that the bulk shall correspond with the sample in quality. This is clause implied. Implied means same example, sir. The bottle of the bottle example that I have given, that is called implied condition. Okay. So class, what is the exact answer? If the sale of good is by sample, so you have to tell me the exact answer. If the seller is showing the sample, so it is an implied condition that sample should be matched the things which I have purchased. So what is the exact answer of 95? The bulk should be correspond with the sample. The buyer should have opportunity to compare the bulk exactly. The goods shall be free from defect, rendering them the unmerchantable, which would not appropriate on this one. So for 94, D is the right answer. This is called implied condition. This is clause implied condition. Next, under the Sales of Good Act, the seller of good is deemed to be unpaid seller. Unpaid seller means the buyer have not given the full price or partially paid. That is called unpaid seller. So he is yet to receive the penalty imposed by him. He is yet to receive the price. He is yet to receive the damages caused to him and all of the above. 96. 96-1. Chandu sir, indoors. Srijan sir, you can slip. Those students who are just sleepy, they can slip. Okay, but I will do all the questions that I have bring for you people. You can slip and always keep remember one thing. जो सोवत है वो खोवत है. Okay, just keep remember this thing. So what is a class unpaid? Unpaid means that he is yet to receive price. So B is the right answer. Exactly. 97. Under the Sales of Good Act, the lien means to hold, can be exercised by the unpaid seller when the goods are possession of the seller, in transit, possession to the buyer, and possession of the seller and buyer in transit. What is the exact answer? What is the exact answer? If your ma'am is energetic, so you have to be energetic. Only 2 days are left, this day and tomorrow. Exactly, Poonam ma'am. Poonam ma'am have completed the sentence. 97. What is the exact answer of 97, class? Possession is with the seller, then only, class, the seller have right to lien. Lien means to hold the property. So this is the exact answer. 97A is the right answer. Next. Under Sales of Good Act, dash is terminated when the goods reach the possession of the buyer. Dash is terminated, that is tata bye-bye, when the goods reach to the possession of buyer. Warranty, condition, lien, and all of the above. What is the exact answer? 98. The dash is terminated when the goods reach to the buyer. Hanji Ashish sir. Okay, Shalini ma'am. Okay. So 96, 98 class, lien is the right answer, that is to hold. The hold will be terminated. Okay, good. 99. Which of the following class is the right of unpaid seller under the sales of good? Which is not correct, class. Again, not correct one. So he can exercise the right of lien when goods are in possession. He can right to stop the good in transit. He can resell the goods, and all of the above is the right answer. 99. Chandu sir, what you ask? $99 question, class. What is the exact answer? 99. Not correct. Right of the unpaid seller, he can exercise right to lien. He has a right to stop. He can resell the goods, and all of the above. 99 question, class. 99. Exactly, 99. D is the right answer, not correct. He can exercise right to lien when the goods is present. This is right one. He has a right to stop. This is right one. He can resell the goods. This is right one. So all of the which is not correct, D is the right answer. Yeah, all are correct, class. All are correct. Which is not correct, all are correct. Okay? So D is the right answer. All are correct. Next. If the buyer pledges the goods without making payment to the seller, so what will happen? If the buyer pledges the good without making payment, pledges means goods as a security. Okay, goods as a security. So seller rights of lien is not affected. Seller right to stop in transit is not affected. Seller rights are affected as a matter of exceptions, and none of the above is the right answer. 100 class. Just make a century. Just make a century. Yeah, 101. If the buyer pledges the goods without making payment to the seller. Yeah, no, it's not which is the following correct. In the 99, you can say correct. All of the above is the correct one. Okay? Yeah, 101 class. Exactly, 10th one. 10th one, C is the right answer. Good. Okay. This is very, very much important slide. This is all about class DRT, Debt Recovery Tribunal. Presiding officer is the highest authority. Tenure is 4 year, 65 year, whichever is earlier. Recovery officer is also there. Registrar is also there. Qualification should be the district judge, and if you want to resign removal, 3-month notice is required. This is very important. In the February, March also, the questions come from this one. Vishal sir, earlier it was 5 year, now it is 4 year. Chairperson DRAT. Chairperson DRAT. Chaired by this one. Appointed by Government of India. Qualification, Judge of the High Court. Indian Legal Service Grade 1 at least 3 year. Presiding officer at least 3 year. And resignation 3-month notice. Okay, this is the exact, and tenure is 4 year and 70 year. Earlier it was 5 year. Neha ma'am, change law hai, change hota hai ma'am. Okay, so this is the right answer. Okay, there is some more question, but before starting the question, I just want to highlight you one thing. Before starting the question, I just want to highlight you that from where you can search the YouTube sessions of YT session of your LRB. Okay, just wait. You have to click on Adda 24/7 site. So please class, please see carefully. You have to write adda247.com. Click on all courses. Click on JAIIB CIB and click on this JAIIB. If you want class, the quick revision of your all the concept, please see this. If you want a quick revision of all the concept of LRB, so this is the JAIIB Power Pack in English medium. And this is the JAIIB Power Pack in bilingual. Power Pack means within 9 to 10 hours, we have covered all the concept. So if you want to complete within 9 to 10 hours, so this is the Power Pack of this one. The price is very nominal. Put the coupon code if you click on Y391. Click on apply. You can see only 643. It means only 643 is the actual price of this Power Pack, in which all the 4 modules will cover, and that English medium Power Pack I have teach this. The recorded session will be given to you. Okay, and if you are the new one and if you want to purchase the new batch of coming November exam, so class, you can simply purchase this is the bilingual batch for the November medium. Exactly, Pramit sir, you can finish. Pramit sir, nothing is impossible. If you have a strong will determination that you have to crack the exam, you can do. Sarja ma'am, I have already told you in bilingual, Praveen sir class is there, and for English medium, if you want to clear your concept, this is class there. And this is the class new batch for November session. If you want a bilingual, I will teach LRB. If you want English medium, I will teach LRB. This is the complete batch. So suppose if you want this English medium batch, this medium batch is going to be start from 24th of June. And this batch contain 130-hour classes, 73 test series, 67 ebooks. So click on view offer if you want to purchase. Put the coupon code Y391. Click on apply. You can see the actual price, 3,679. Okay, so this is the exact English medium batch for the November session, okay? And if you want the YouTube session of Adda 24/7 YouTube channel, sorry, Officers Adda, you have to write Officers Adda 24/7 YouTube channel, okay? Click on Officers Adda YouTube. This is not our channel. I'm going to show you the Officers Adda. This is Officers Adda YouTube channel. Click on this one. You have to click now the playlist. If you click on the playlist, you can see the all videos of your this one. LRB videos are this one. I have told you now, if you want the complete module chapter wise questions, so this is the LRB very important questions, and for the English medium, this is the LRB English medium session. So these two are the YouTube session that is free to all of you. You can see the questions here. Okay, you can see the questions here. Okay, now Kapil Mehta sir, CIB batch is also there. Exactly, Parmeet sir. So class, now what is the exact answer? Only few question we will do. Yes. Only few question we will do. 3 persons have joined together to share the profit and return arising from the property, which is the correct one. The person shall be called partners. The group of person can be called firm. The name under which they shall carry the transaction is called the firm name, and it is not the partnership firm. What is the exact answer? First one. What is the exact answer of first one, class? What is the exact answer of first one? I have shown you all the things. The exact answer of this one, first one is excellent. D is the right answer. D is the right answer. Okay? That it is not the partnership firm, since they shall not carry any business. So that's why this is not the partnership firm. Okay? Exactly. Second one. When no provision is made by a contract between the partners about the duration of the partnership, so what it will be called? Partnership for unlimited period, limited period, at will, or particular partnership? What is the exact answer? Just tell me 1, 2, 3. No need to write 101, Simranjeet ma'am. No need to write 101. That's it. Second one, if the no duration is written, if the no duration is there, so the exact answer is partnership at will is the right answer. C is the right answer. Okay? Next, if the partnership is for the fixed period and it is continued even after the fixed period, it becomes illegal relationship. It converted into partnership at will. It become partnership for unlimited या particular partnership. Third one. Third one, class. If the partnership is for fixed period and it is continued even after the fixed period, so what it will be called? Exactly, Sudeep sir, Gitanjali ma'am. No, Baba. If it is continued even after, so that is called, class, converted into the will. B is the right answer. Okay, B is the right answer. Next one. Come on. Okay, we have to do very quickly. X, Y, Z have entered into partnership for carrying the specific venture. It is called specific. Journal, partnership at will, fixed period, and particular partnership. Yes, class. Fourth question. Specific is there. Specific. Specific means? Specific means class, specific. Exactly, that is called particular partnership. D is the right answer. Good, Gitanjali ma'am. Next, which of the following is a part of journal duty of the partner? Again, I am saying module A, B, C questions are in the YT session from 26th of May. So please go to the playlist to see all the questions of A, B and C. Which of the following is a part of journal duty of partner class? Fifth one. Journal duty of the partner should not make secret profit. No. Yes, sir. Exactly. Fifth one. D is the right answer. This is the journal duty of the partner. This is the right answer. Exactly. Good, Preeti ma'am. Next. The difference between partners on the matter relating to the business of partnership firm is decided by, it means the major decision will be decided by majority of the partners if it is ordinary matter. All partners are for the matters. C is majority of the partners of matter. This is the option. And D is all the above are correct. What is the exact answer of sixth one class? Sixth one. The majority of the partner, if it is in ordinary matter, all the partners later change the business firm. First one class, what is the exact answer? Sixth. Sixth one. Sixth one class, the exact answer is given in A option. The actual answer is given in the A option. No, it's the A1. The majority of the partner if it is in ordinary matter and all the partner if it's relate to the change in the business of the firm. This is the right answer. Next one. Which of the following matching the parties in the contract of indemnity is correct class? Now the question from the contract. So which of the following is correct about the indemnity? Now it is class indemnified, indemnifier, indemnified, indemnity holder, indemnity holder, indemnifier, indemnity holder, indemnified. You have to tell me the exact person's name. What is the exact answer? Piyush sir, only few questions are there. Only few questions, okay? Few questions are there only. So what is the exact answer? Just tell me. Yeah, seventh one, exact answer. Seventh one, exactly. C is the right answer. Indemnify holder means to whom we are. This is the person who is safe from the loss, and this is the person which make the promise, that is called this one. Okay, this is the exact answer. Excellent. Next. Which of the following types of loss cannot be recovered under the contract of indemnity? What is contract of indemnity? It is simply, you can see the example of insurance all are the example of the contract of indemnity, okay? Insurance examples. So, damages paid in the suit, costs paid in the suit, payment made in compromise that are not contrary to indemnity, and none of the above is the right answer. What is the exact answer of eighth one? Simranjeet ma'am, why not A? The person who is from safe, ma'am, this is indemnified, and the party who make the promise. Okay. Exactly. This is also class. Indemnified is also called indemnity holder, but ma'am, you know, in the Indian Contract Act, ma'am, I am just telling you, in Indian Contract Act, the indemnity holder word is given. Okay, ma'am, indemnity holder word is given. That's why I have tick mark on the C1. Otherwise, indemnity holder class, please see this. It is also called indemnified. It is also called indemnified, but according to the Act, ma'am, this word is given. Okay. Now, next one. Eighth question. Are Avin sir, don't see the Macmillan book here, just understand. Difference between indemnified and Renu ma'am, indemnified and indemnity holder is the same answer. The loss is happened to these persons. Okay, an indemnifier who give the compensation, that is called indemnifier. So for this one class, the exact answer is for the eighth one. Which of the following is loss cannot covered, recovered in a contract of indemnity? So for eighth one, the exact answer is D is the right answer. Good. Next. Now quickly class, which of the following contracts are essentially the contract of indemnity? Contract to pay compensation, contract to buy immovable property, contract of insurance, and contract providing the certain services. What is the exact answer of A and ninth one class? Just tell me the example of contract of indemnity. Example of contract of indemnity. What is the example of this one? Ninth one, insurance is the right example. Absolutely right. Next question. The dashed number of parties are there in number of indemnity and contract of guarantee. How many parties are there? 2, 2, 2, 3, 3, 2, 3, 3. What is the exact answer? Parties, indemnity, 2. Exactly. This is the 2 is the right answer. 11th. First of all, see, this is very important concept. Consumer Protection Act 1986 and 2019, both concepts are important. The main important is class, the pecuniary jurisdiction. The pecuniary jurisdiction is the important one. District court up to 20 lakh, state 20 lakh to 1 crore and national above 1 crore. The change has been happened in this one 2019. District court up to 1 crore, state 1 crore to 10 and national above 10 crore. And there is also change in class 2021. In 2021, district up to 50 lakh, state 50 lakh to 2 crore and national above 2 crore. This is the drastic change in 2021. Please see this class. Okay, so this is important one. Next, which of the following parties do not match in the contract of guarantee class? Come on, wake up. Which of the following parties do not match in the contract of guarantee? 11th one. A person making the promise is surety. Person for whom promise is made is called creditor. The person to whom promise is made is called principal debtor, and all of the above is the right answer. What is the exact answer? What is the exact answer? Yes, what is the exact answer? Which of the following do not match the contract of guarantee? Yes. 11th one. Exactly, 11th one do match. Which of the do match the contract of guarantee? The person making the promise, 11th one, the person from whom promise is made. Creditor, the person to whom promise is made. Exactly. So this one, D is the right answer. Excellent class. Next. In a contract of guarantee, the guarantor is benefited in any manner, no consideration passes on the guarantor. That is so simple. Contract of guarantee, principal debtor is there, creditor is there, surety is there. Surety is working on the behalf of principal debtor. Surety is working on the behalf of principal debtor. It simply means that there is no need of consideration for that work to the surety. So is that right or not? 11th one. 11th one, what is the exact answer? Twelfth one, yeah, 12th one exact answer is 11th one. And we will do match. Parties do match in this one. Person making promise is surety. The person for whom promise is made creditor. Person to whom the promise is made principal debtor. D is the right answer. Person making the promise. Acha, do match in a contract of guarantee. That is exactly surety, exactly. Now the ma'am is also, I think, sleepy. 11th one, A is the right answer. Surety is the right answer. Exactly. 12th one, A is the right answer. Exactly. Okay. Next, 12th one. So in the contract of guarantee, the guarantor is not benefited in any manner. So no consideration passes. So is that right or not? 12th one. Parul ma'am, you have to remember 2019 and 2021 jurisdiction, okay? Exactly, Manvinder sir, A is the right answer, 11th one, exactly. So what is the exact answer of 12th one, class? C is the right answer, that the benefit obtained by the principal debtor is the consideration of guarantor, no need to give the extra consideration. So for 12th one, Rajesh sir, exactly C is the right answer. Good. Next, a guarantee which is extended to a series of transactions, just like for the cash credit, it is called omnibus, continuing, regular or irrevocable. District code to this one is 45, state to national commission 30, national to state commission Chandu sir 30. आ गया समझ में? 13-1 class, it is called the continuing guarantee is the right answer. Next, if the guarantor dies, what is the position of liability? Guarantor dies in the contract of guarantee. Whether it is called he continue to be liable for the loan, for outstanding balance in the loan, the estate of guarantor remains liable. For the outstanding balance in the loan as well as for the any future debit of the account, estate of this one, yeah, neither for the outstanding balance in the loan nor for the any future debit. If the guarantor dies, 14-1. If the guarantor dies, class, guarantor dies, please tell me the exact answer of 14-1. If the guarantor died, for the outstanding balance in the loan for the estate of the guarantor remains will be liable. B is the right answer. Exactly, Akhil sir. Okay, next. If the terms of a contract guaranteed by the guarantor are changed, so what is the position of liability of the this one guarantor? If the contract guaranteed by the guarantor has changed, it means if the term have changed, so what is the position of guarantor? Yes, class. What is the exact answer of 15-1? 15-1, what is the exact answer? What is the position of liability of the guarantor? This is very good question. Position of the guarantor. Chini ma'am, only one jurisdiction. Only one jurisdiction is there, ma'am. Okay? Only one jurisdiction is there, ma'am. So what is the exact answer of 15(1)? Exactly, C is the right answer. If any contract guaranteed is changed, so the guarantor continue to be liable if the change is with the concurrence of the guarantor. C is the right answer. Okay? DRT to DRAT, 30 days are there. In the previous one, 45 days was there, but it is now simply. Okay? So class, I think that's all for today's class. We have generally covered the module C and module D question, but again I am saying if you want to cover module A, B, C, one day is there. Just take holiday tomorrow and cover all the YT sessions in which the questions are there. Okay? So that's all for today's class, and please do not forget to see the session of tomorrow, Praveen sir, at the evening. Okay class, so that's all for today's class. A very all the best to all of you. A very all the best to all of you from the bottom of my heart, and you will definitely crack the exam if your concept is clear, if you have attended the YT session, if you have covered the mock paper and you have revised the all things. So 4 things you have to do if you want to crack your LRB exam. Okay, so thank you so much class. We will meet after you will crack your exam. Okay, thank you so much. Okay, thank you so much.